Go ahead and continue with the announcements, please.
Thank you, Judge. Drake McKeska, attorney for the department. Ms. Lewis.
Belong permanency specialist.
Kathleen Savage, standing in for Richard Saldivar, the attorney for the respondent, Father Robert Pagel. I believe he should be here. That he might be the one connected by phone. Whoever is on the phone line, if you can unmute and announce your name.
I'm here, Robert Pagel.
We're ready, Your Honor.
Thank you.
Stephanie Cash, Hill Country Casa, Guardian Ad Litem Supervisor. Kim, will you unmute and announce, please?
Yes. Kim Richardson, Hill Country Casa, Guardian Ad Litem for Alyssa and family.
All right. Ms. Swallow has just logged in. Still don't have any word from Ms. Fuller.
Judge, I did receive a voicemail from her earlier, and I just checked the text of that voicemail. She is in Junction County, or I guess Kimball County, for an in-person hearing. So I don't know if she's going to be available to hop on or not.
Do we need her in order to proceed?
I don't think so, Judge. We do have an agreement for how we're wishing to move forward today.
And you've got her signature on it?
There were email communications between the parties, Judge, where she indicated that she was in agreement with what we were doing.
Okay. That's good enough for me. Ms. Swallow, would you announce for me, please?
Yes, Judge. Anna Swallow, attorney ad litem for the respondent, mother, ready.
All right. Mr. McKeska, I think we've got announcements from everyone. If you want to go ahead and state the terms and conditions of the agreement, please.
Yes, Judge. So we don't necessarily have a formalized agreement as far as bullet points are concerned, but the parties did agree that we would seek an extension under 263-401 of the Texas Family Code in order to allow the foster home, Miss Bannock, or the foster mother, Miss Bannock, to have Alyssa in her home for the required 6 months in order for the home and for Alyssa to qualify for PCA benefits. So the department did file that motion. I don't recall the exact date we filed it, but I know we did file it.
Okay. Is that the entire agreement?
Yes, Judge.
Okay. Ms. Swallow, that's your understanding of the agreement? I saw you nod your head.
Yes, Judge. I'm sorry. I'm on my phone. It's kind of complicated. Yes, that is the agreement.
Okay, thank you. Ms. Savage is here for Mr. Saldivar. What did he indicate to you, Ms. Savage?
Yes, Your Honor. He was in agreement to that as well.
Okay. Mr. Pagel, can you unmute for me, please?
Yes, I'm unmuted.
All right. Did you have an opportunity to discuss this agreement with your attorney?
I did not.
All right. Do you understand that the case is being extended today for another 6 months?
Yes, I understand.
Okay. Are you opposed to that?
No, not at all.
Okay. All right. Miss Fuller is not here, but Mr. McKeska has indicated through attorney correspondence that she is not opposed to the extension. Casa, Miss Richardson, what is Casa's position on the extension?
We are in agreement, and I believe Mrs. Cash would like to speak for a moment.
Okay.
Thank you, Judge.
I'll give a report as to Alyssa when you're ready for that, Judge.
Go ahead. You can do it now.
Alyssa has enrolled in school at KISD. Her ARD was a couple of weeks ago. She's involved with a behavior intervention program. It seems like a really cool program. It's designed to support her mental health needs while keeping her in the classroom as much as possible. We were really glad that Alyssa and mom and the placement all attended and participated in that ARD. Since that time, Alyssa is testing those boundaries that were put in place. And she's somewhat hesitant to open up in therapy. I think it would be helpful for Alyssa maybe to have a visit with you. And I think it would be very helpful and beneficial for the school, the therapist, and the placement of Alyssa to all be on the same page about how to handle Alyssa's behaviors and the continuity of care for her. We'd like to request that Belong is ordered to facilitate contact between those individuals to help smooth that continuity of care. Mom's doing really well. She recently got a raise at work. We were not able to come to an agreement on a date for a mediation, but as the others have said, I think we're all on the same page with a plan of an extension to allow time for that PCA agreement in Ms. Bannock's home. Since Alyssa was required treatment in RTC that took her out of the area, she hasn't met those residency requirements yet. That said, she will meet those residency requirements in May, and so we're hopeful that perhaps this case could close in June, barring any major issues arising.
Okay. Thank you. Ms. Fuller, I have heard from all the parties, and Mr. McKeska explained to me that you all were in communications, and he was under the impression that you were in agreement with the extension. Is there anything else that you want to add?
Okay. I was trying to get on and there was an issue with the connection, but yes, I'm in agreement with the extension. I think that would be in the best interest of Alyssa. She did ask for me to bring up a couple things, and that was for her to be able to have contact with a paternal grandmother that wasn't able to be studied in this case, but she would like to have some contact. So I need to get everybody's opinion on that. But I do think it's in her best interest for us to be able to resolve this with a PMC, with PCA, hopefully with Ms. Bannock and the mother and father.
All right, thank you. Mr. McKeska, I don't know if you wanted to put on any evidence with Ms. Lewis as far as best interest go in extraordinary circumstances.
Yes, Judge. Okay, and how are you currently employed?
With Belong Permanency Specialist.
Okay, are you the permanency specialist assigned to Alyssa's case?
Yes.
Okay, and you've heard the discussion today regarding the request for extension, correct?
Yes.
And do you believe that that request is in Alyssa's best interest?
Yes, I do.
And can you just briefly explain for us why you believe that the extension is in Alyssa's best interest?
It gives Alyssa time to continue in Ms. Bannock's home and get to that 6-month mark so we can get Ms. Bannock some assistance for permanency.
Okay. Is Ms. Martin continuing to engage in services at this point?
Yes.
Okay. And what services is she currently engaged in?
She just continues to do random drug testing along with her individual counseling.
Okay. And with regard to the other elements of her family plan of service, has she been able to successfully complete those?
Yes.
Okay. And do you believe that she's making a good faith effort to complete the services on her family plan?
Yes, I do.
Okay. And do you believe that the court retaining the case on its docket will allow Ms. Martin additional time to be able to complete those services on her family plan?
Yes.
Okay. With regard to Mr. Pagel, are there any services that he's able to engage in at this time?
Not at this time.
Okay. And have you had contact with the facility that he is incarcerated in to see if there are any services available?
Yes, the courtesy worker has had contact with them, and at this time she wasn't sure that she could get any services set up for him, but was going to continue to try.
Okay. Is there any ongoing contact between Mr. Pagel and Alyssa at this time?
No.
Are there plans to begin contact between Alyssa and Mr. Pagel?
I know last time we had discussed addressing that in Alyssa's therapy, so I can follow up on that.
Okay. And do you believe that the additional time on the court's docket will allow for that process to begin as well?
Yes.
Okay. Just so I can touch the other elements in case we need to have a permanency hearing today, is Alyssa up to date on all of her medical and dental appointments?
Yes.
Are there any medical or dental concerns at this time?
No.
Is Alyssa receiving psychotropic medications?
Yes.
Has she had her regular medication reviews?
Yes, she does.
Okay. Have there been any major changes regarding her psychotropic medications?
No.
Okay. You said that Alyssa's engaged in therapy currently?
Yes.
And do you have any information regarding how she's doing in her therapy?
I have been told that she is a little resistant on talking to this new therapist. She feels like she doesn't need therapy, but her whole legal party has talked to her about it and continuing to do her part in that. And I think she's going to continue working with that therapist.
Okay. Do you have any?
Oh, sorry.
Do you have any concerns for Alyssa in Miss Bannock's home at this time?
Not at all.
Do you believe the continuation of Miss Bannock's home is in her best interest?
Yes.
Pass the witness, Judge.
Start with you, Ms. Swallow.
Thank you, Judge. Ms. Lewis, are you requesting that the court's prior orders regarding contact with Mr. Pagel remain in effect?
Yes.
More specifically, that the therapist is in complete control of any introduction of Alyssa to Mr. Pagel?
Yes.
And that no one is allowed to discuss Mr. Pagel or paternity with Alyssa except her therapist?
Yes.
Okay. Thank you. I pass the witness.
Ms. Savage.
Yes, Ms. Lewis. Can photos of Alyssa be sent to Mr. Pagel?
Let me follow up on that and I can get back with Richard.
Okay. And then in regards to services, if he is able to complete any services while at his facility, will Belong be willing to accept those?
Yes.
And any family names or relative names provided by Mr. Pagel to Belong is also willing to look at and consider?
Yes.
I'll pass the witness, Your Honor.
Ms. Fuller.
In regards to contact with Rebecca Martin, does the department oppose any contact with Miss Martin, the paternal grandmother?
I do not believe so. I think we possibly should talk about it with her therapist, but I don't believe so.
I mean, how often is she even going to therapy? My understanding is she doesn't really want to go.
Weekly, but she is
Okay.
going.
And can you provide notes from her therapist?
Yes.
Okay. And so will you please contact me or let me let the therapist know that that I can speak with her in regards to having this contact with her paternal grandmother?
Yes.
And the paternal grandmother was offered as a placement, but she did not want to be studied, correct?
Correct.
Have you received any other information from Mr. Pagel in regards to any other relatives?
I have not.
Okay. I'll pass the witness, Your Honor.
Any other questions?
No, Judge.
Any other witnesses?
No, Your
Judge,
Honor.
I'd like to call my client because I don't know the answer to something. I mean,
You may.
thank you. Has she been sworn in, Judge?
I believe so. I swore everybody earlier.
Okay. Thank you. Miss Martin, can you hear me?
Yes, ma'am.
Okay, and I hate to put you on the spot like this. My apologies, but I need to know the answer to this. What is your position on allowing Alyssa contact with Rebecca Martin?
Honestly, I have not put much thought into that at all because last I heard anything, I was under the impression that she didn't want that. So, and then honestly, I think Alyssa should have that contact with her dad before bringing in all these other family members that she's never met before, if that makes sense.
Okay, so you're wanting to follow Alyssa's desires coupled with a therapeutic recommendation and to start with Mr. Pagel first.
Yes, ma'am.
Thank you. I pass the witness.
Any other questions for Ms. Martin?
No, Judge.
Okay. Anything else that you want to add, Ms. Fuller?
Your Honor, I did want to briefly call Mr. Pagel.
Okay, you may.
Mr. Pagel, can you hear us? Are you able to?
I can.
Perfect. At your facility, are there any services that you might be able to engage in? Maybe parenting or any kind of support groups?
Actually, I'm in 2 classes right now. One's called Voyager, one's called Quest for Authentic Manhood. They both have sections that are about parenting. I've also signed up for 3 other classes and signed up for the faith-based dorm, so I should be getting moved to the faith-based dorm maybe within the month. I'm not really sure. That depends on who gets removed from the faith-based dorm at the time. So, but I have signed up for that. I've signed up for AA. AA is once a week. I mean, I'm doing everything here that I can.
Perfect. And are there any other relatives or family members that you would possibly want to be studied for placement should that be needed at some point in the case for Alyssa?
You know, honestly, you know, I got 3 sisters. I got my mother. I don't understand what my mother's deal is. She hasn't said anything to me in a while either, but I'll keep trying with my mother. Other than that, no.
Okay. And what are your sisters' names?
My sisters' names, one's Haley Adair, the other one's Carissa Adair, and then I have an older sister named Kayla Fiddler. And they're all my half-sisters, but they're all my mother's daughters.
And in regard to contact with Alyssa, is that something that you are wanting once Alyssa is in a place for that to begin?
Absolutely. I don't see a problem with it, especially if it's only through a therapist. It's not like I'm writing her inappropriate things. I mean, I'm a grown man. I'm here to have her back as a father should, but I'm not going to say anything out of the ordinary or inappropriate. So, yeah, I think I should have some sort of contact with her. I'm her father.
Thank you, Mr. Pagel. I'll pass the witness, Your Honor.
Any other questions for Mr. Pagel?
No, Your Honor.
All right. Anything else that you want to add, Ms. Fuller?
Hear you. No, I recommend that Alyssa stays there. I'm hoping she does engage in therapy. I would ask that I be provided some therapy notes, and I would ask that they look into some kind of contact with Miss Martin. She wasn't available as a placement according to her, but Alyssa did want to have some contact. I mean, she can't have much contact with her father since he's incarcerated, but it would be nice for her to know that she does have extended family.
Thank you, Ms. Fuller. Ms. Richardson, anything you want to add?
No, sir, not at this time.
Okay, thank you. Then for the purposes of the final trial, which finds that both parents are in attendance and that the parties have an agreement to extend this case and reset the final trial, court finds pursuant to Chapter 262, 401B, that extraordinary circumstances necessitate the child remaining in the temporary managing conservatorship of the department, and the court will continue to appoint the department or belong as a temporary managing conservator, find that that's in the best interest of the child. Court will retain the suit on the court's docket for a period not to exceed 180 days, and the new dates are going to be the dismissal date is November the 2nd, 2024. November 2nd, 2024. Our next permanency hearing after today is going to be June 5th, 2024. June 5th, 2024 at 9:30. And then our final trial is going to be September the 4th, 2024 at 11. September
At what time, Your Honor?
11.
Okay.
Court finds that the extension is in the best interest of the child. And those are the new dates of our case here. For the purposes of today's permanency hearing, court finds that what are you classifying the permanency goal at this time, Ms. Lewis? I don't know that I heard that.
I would consider family reunification with fictive kin conservatorship.
Okay. All right, and the court will make that finding. I think that's the closest thing we can come up with. It's family reunification, but the conservatorship is going to be fictive kin, according to the parties' plan here. Court finds that the child is up to date on all of her checkups, that her psychotropic review is up to date, that she is in therapy, and the placement is meeting her needs and in her best interest to continue, and it's appropriate. Court finds that her educational needs are being met at this time. Court finds that the mother is in compliance with her family service. And I understand that Mr. Pagel is incarcerated, but from what he said, And I didn't hear any controverting evidence. He's making attempts to engage in whatever he can do. And in some other cases, when there have been that many things available to parents who are incarcerated, and they're trying to set forth a plan within the constraints of what they're doing. And I'm not just talking about going to one class. I mean, he's doing several things. I think I'm going to find that he's in minimal compliance. He can't visit, obviously, at this time. He's not having contact with the child. So we're not able to evaluate that, but he is making efforts. So I'm finding that he's in minimal compliance and making attempts to engage in the services available to him. I want Belong to look at Haley Adair, Carissa Adair, and Kayla Sidler just on a preliminary basis. Don't start doing background checks yet. Let's just look and see if these folks are people that we should be looking at for contact or whatever. I'm also going to order Alyssa to have a meeting with me as soon as possible. Miss Savage, if you let Mr. Saldivar know just to get with Miss Greenlee and we'll get it on the books. Again, as I stated a moment ago, our next hearing is going to be the permanency hearing, June 5th, 2024 at 9:30. I have to admonish the parents. The state of Texas normally gives parents in TPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. In the event you cannot do so, your rights to your child are subject to restriction and termination. We just extended this case. So that time period, it's going to be longer. It's going to be 18 months, but it's still going to end. Okay, it's not going to go on forever. So you've got to continue to work in this case like you have been. You can't slack off. You can't quit. Okay. Mr. McKeska, is there anything I failed to address?
No, Judge.
Okay.
Your Honor, did you say that you wanted to meet with Alyssa?
Yes.
Okay, I will get that set up with Miss Greenlee.
Thank you. All right. Thank you all for your time and your service, Miss Martin and Mr. Pagel. Good luck to you both. If nothing further, I'll place the excuse. Court is broadcasting outside of Kirk County. Is there any objection?
No, Judge.
No, Judge.
With that, Mr. McKeska, will you please begin the announcements?
Thank you, Judge. Drake McKeska, attorney for the department. Ms. Harris.
Cindy Harris, permanency specialist.
Joe Ramirez, permanency supervisor.
Kathleen Savage, attorney for the respondent father, Mr. Castro. Mr. Castro, can you announce your name for the record, please?
Yes, ma'am. Jamie Castro. I'm the father.
Jennifer Harris, attorney ad litem for the child. I'm ready.
Is anybody who hasn't announced yet, go ahead and announce now, please.
Asa ad litem.
Goldie Robson, Hill Country Guardian ad litem supervisor.
I'm Blake Kuykendall. I'm the mother.
Sir. Yes, I'll need you to announce, please, sir. Miss Kuykendall, the gentleman that's with you, I need him to announce his name.
Unmute. The name is Gary Strunk. For support for Jamie and Blake.
Okay, thank you. All right, anybody that hasn't announced yet? Ma'am, I see you talking, but you're muted.
I'm Sissy Strunk.
Thank you.
And I'm here.
I didn't get her name, Judge. I couldn't understand her. This is the reporter.
Sissy Strunk.
It's Susie Strunk. I don't know how you spell the last name.
Okay. Thank you.
All right. I have in my notes, well, we don't have Miss Acosta yet, just for the record, but I've got a full docket, so I've got to keep moving. I have in my notes that there's going to be a requested motion to retain on this case, Mr. McKeska.
That's correct, Judge.
All right. All right, you want to go ahead and put on your evidence and support?
Yes, Judge, I'd like to call Ms. Harris.
All right, and let me ask you this question. Is it a completely agreed or is there opposition?
Judge, I don't believe there's any opposition to the motion.
No, Your Honor, there's not.
Okay, then if you just want to put on best interest and extraordinary circumstances, that would be sufficient.
Yes, Judge. Ms. Harris, can you please state your name for the record?
Cindy Harris, Privacy Specialist.
And are you currently employed by Belong?
Yes, I am.
Okay, are you the privacy specialist assigned to this case?
Yes.
Okay. Can you update the court on how Ms. Kuykendall is doing in her family plan of service?
Yes, so since our last court hearing, she had been taking a break from her services due to the emergency birth of her son, Arrow. Since then, she has returned to her appointments with Mary Beth for substance abuse counseling. She returned on February 28th of 2024. On January 10th, she admitted to using methamphetamines approximately 5 days before. So she is scheduled to complete an updated drug and alcohol assessment on March 27th. After the birth of her son, and after being released from the hospital, she had a catheter in. So beginning on February 1st, she started submitting to weekly drug testing. Her first UA was February 1st, which was negative. All her UAs every week have been negative, and her last hair follicle was February 8th of 2024, which was also negative for all substances. She has maintained contact with Belong, and she has attended all of her visits after being released from the hospital.
Okay. Outside of the substance abuse services, is she attending any other services at this time?
Outside of the substance abuse services, no, she had already completed her parenting course.
Okay. Was she ordered to complete individual counseling?
Yes.
Okay. Is she attending individual counseling?
She is attending the counseling with the substance abuse counselor.
Okay. The counseling with the substance abuse counselor, is that only addressing substance abuse, or is it addressing additional issues as well?
To my understanding, it's only addressing the substance use.
Okay. During the course of this case, has Ms. Kuykendall made a reasonable effort or diligent effort to complete her services?
Yes.
But based on the events that occurred in January, do you believe that it is necessary for her to continue to engage in services?
Yes, I do.
Okay. Do you think the court retaining the case on its docket will allow her the opportunity to complete those services?
Yes.
Okay. And do you believe that it's in Atlas's best interest to have the court retain the case on its docket?
Yes, I do.
Okay. With regard to Mr. Castro, can you give the court an update on how he's doing his family plan?
Yeah, so he had also been taking a break from his services due to the birth of his son. He has, however, continued or will resume with his appointments with MHCD starting April 18th of 2024. He has continued to remain employed and has provided me with his recent pay stubs to confirm that he is employed. He is scheduled to complete a couples counseling session on March 8th. He has started individual counseling with Mindful Innovations since December 18th. His counselor reports that he has been attending consistently. He's addressing various aspects of his well-being, coping strategies, and history of traumas. He is reported to be engaging and demonstrating a commitment to counseling. He completed an updated drug and alcohol assessment on February 9th of 2024. He was recommended to continue engaging on his current services and engage in 12-step meetings. Mr. Castro reported that he had completed an outpatient program in August of 2023. He reported that he was engaged in substance abuse counseling, and he also reported that he was attending one NA meeting per week, and that's what they recommended that he continue doing. The outpatient treatment program that he was referring to is the Kirk County Phoenix program that he did complete in August of 2023. He is engaged in counseling, and the NA meetings, he reported that he attended about 2 or 3 meetings before the birth of his son, but I have not received sign-in sheets for those meetings. He has been testing weekly. He has been negative on all of his UAs. He was requested to submit to a hair follicle on February 8th. However, he did not have enough hair to test. He was sent to complete a hair follicle again on February 24th, which was negative for all substances. He has maintained contact with Long, and he has attended his scheduled parent-child visits.
Do you believe that it would benefit Mr. Castro for the court to retain the case on its docket to allow him to complete services?
Yes, I do.
Okay. Are the parents attending parent-child visits with Atlas?
Are the parents what, I'm sorry?
Are they attending parent-child visits with Atlas?
Yes, they are.
And how are those visits going?
The visits that I've observed have been appropriate and positive with Atlas.
Okay. What is the current visitation schedule?
Once a week for 3 hours.
Okay. Are those supervised or unsupervised?
Supervised.
Okay. Are you recommending any changes to that visitation schedule today?
At this time, no.
Okay. What would the parents need to do in order to move those visits from supervised to unsupervised visits?
I believe they would need to continue to demonstrate that they can remain sober for a prolonged period of time.
Okay. Do you have concerns for that, given that both parents have relapsed during the course of this case?
Yes, I do.
Okay. How is Atlas doing in his current placement?
He is doing really well. He is up to date, medical, dentals. He gets along well with his foster siblings, and he seems to be doing really well.
Okay. Do you have any concerns for the care that Atlas is receiving currently?
I do not.
And the current placement's also very supportive of the parents in working their services, correct?
Yes, they are.
Okay. Pass it, Mr. Judge.
Before we move on, I just want to make sure. Tell me what your permanency goal is as of today again, Ms. Harris.
The permanency goal is fictive kin adoption with the concurrent goal of family reunification.
Okay. And then I know you stated all the services that they're doing and you talked about their relapse, but what would you state their level of compliance is as of today?
As of today, I would say partial, just because of the recent relapse and admitting to using.
Okay. Ms. Acosta, if you could announce, and then you can ask Ms. Harris any questions that you might have.
Yes, Your Honor. Irene Acosta for the Mother Blake Kuykendall. I'm ready. Ms. Harris, with regard to Ms. Kuykendall, what efforts have you made to assist Ms. Kuykendall in addressing substance abuse?
Ms. Kuykendall has received assistance from various service providers as far as substance use. She was referred to a substance abuse counselor. However, she chose to go with her counselor at MHDD.
So with regard to her counselor at MHDD, is her counselor at MHDD assisting her with substance abuse?
Yes, that she sees Mary Beth. She's an LCDC.
And is that acceptable to belong? Is that being accepted as part of her service plan?
For substance abuse counseling, yes.
Okay. And so for substance abuse counseling, is she in compliance with that portion of her service plan?
Yes.
Okay. And has she completed an OSAR?
She is scheduled to complete it March 27th.
All right. Is she currently engaged in counseling?
She had taken a break from her services, so she's scheduled, or she resumed her appointments on February 28th.
Okay. And the break in her services, was that due to the emergency that she had in the hospital?
Yes.
Okay. And so is it understandable that she would have taken a break from her services given that emergency?
Yes.
Okay. And so that's not being counted against her at all, is it?
No.
Okay. Is she attending her parent-child visits?
Yes, she is.
Okay. You said that she's in partial compliance. What is causing her to not be in full compliance?
Her admitting to using methamphetamines was actually right after a drug test and while she was pregnant.
Okay. So is she addressing that now?
Yes.
All right. And moving forward, are you committed to assisting her in addressing those issues?
Yes.
And do you think that those issues can be resolved while continuing to engage in services in this extension?
Yes, I do.
Is there anything else that Ms. Kuykendall needs to be addressing?
As of now, no.
All right. I'll pass the witness, Judge.
Ms. Savage.
Yes, Ms. Harris. So the reason Ms. Kuykendall is not in compliance is because 60 days ago she admitted that she had a one-time relapse. Is that correct?
Correct.
And since then, all her UAs have been negative, correct?
That's correct.
And her hair test was negative. Is that correct?
That's correct.
And that goes back 3 months. So this relapse was truly a one-time relapse, and she was honest with Belong when she made that admission. Is that correct?
Yes.
And she's using the tools that she's learned through her services to get sober again and to commit to sobriety, correct?
Yes.
Okay. And in regards to Mr. Castro's relapse that you're referencing, that relapse was October timeframe. Is that correct?
That's correct.
Okay, so you're saying that he's not in compliance even though he's doing every single service. All his UAs have been completely negative. His hair test was negative because he had a relapse 6 months ago, correct?
Yes.
Okay, but he's making progress in therapy and he's engaging in that service, correct?
Yes.
He's employed at this time, correct?
Yes, yes.
He's visiting with his child at this time, correct?
Yes.
And he's bonded with his son?
It appears so.
He communicates with Belong?
Yes, he does.
He completes every UA as requested?
UAs, yes.
Okay. And we had the not enough hair in early February, but he did complete that hair test for Belong, as you stated, February 24th, correct?
Correct.
Okay. What service does Mr. Castro need to continue to engage in order for him to be reunified with his son?
He needs to continue to engage in the individual counseling, follow the recommendations that were provided to him on his drug and alcohol assessment, continue with his appointments at MHDD, and continue to maintain a sober lifestyle.
I'll pass the witness, Your Honor.
Ms. Acosta, you've already asked questions. Ms. Harris, I think, is next on the list.
What is the status of the parents' relapse plan?
I have asked MHDD to work on that relapse plan with them. I believe they will be addressing that at their next meeting on the 8th.
Do you consider that especially important, considering we still have occasional positive drug tests?
Yes, I do.
Do you consider it important, considering neither parent has admitted to relapsing before testing positive?
Yes.
As far as compliance for either one of them, can the Belong consider them in compliance when they're living together and somebody is testing positive every few months?
No.
And they just got started back in their services, correct?
Yes, that's correct.
Which is understandable given the circumstances, right?
Yes.
Is that why you think that we need to be able to have this extension so they have an opportunity to get in full compliance?
Yes, I believe they need some more time.
And not only do they need to get in full compliance, do they also need to maintain compliance consistently?
Yes.
I'll pass the witness, Judge.
Mr. McKeska, any follow-up?
No, Your Honor.
Does anybody else have any other witnesses to call?
No, Judge.
Anything else that you want to add, Ms. Harris?
Atlas is doing great. He's being well taken care of. The placement is very supportive of his relationship with his parents. I will just reiterate what I said at the last hearing, that a relapse plan is absolutely essential. I understand that relapse can be part of of recovery, but these are two parents that have had historical drug use. They need to have a plan in place to make sure that their children are going to be safe when somebody in the home does relapse. And and that needs to occur before a drug test.
Yes, Your Honor. CASA would also be in agreement with Belong and with Jennifer Harris that the parents are not in compliance, or as Cindy said, partial compliance due to their extensive history. We would want to see also that all of the recommendations of engaged services be followed as requested. We want to also see that for maintained compliance. And as Jennifer Harris had mentioned, we think it's very important that a relapse plan is put in place as we move forward. Atlas is doing well where he currently is, and visits are going well. But due to the history of the parents with their drug usage, we want to see full compliance when it comes to all services that have been recommended.
Thank you, Ms. Goss.
Your Honor, just argument.
Go ahead.
Your Honor, I'd argue that the parents are in compliance. Mr. Castro had a relapse back in October. Ms. Kuykendall admitted to the one-time relapse, and both parents use the tools, use their services, and are starting to re-engage and get sober and stay sober. They've been testing. They're compliant with Belong. They're communicative. They're engaged in everything. This is what we expect our parents to do. We expect them to get started. We expect them to trip and fall down, but when they do, to get back up and get started again. And that's exactly what they have done. So to penalize Ms. Kuykendall for being honest 60 days ago when she had a mess up, she messed up, she made a poor choice, but she was honest, she's getting re-engaged, she's been sober. And the same for Mr. Castro. He's been sober for an extended period of time. This relapse they're referring to that they want you to find him non-compliant for, again, was 6 months ago. So I do think, obviously there's still time to continue to monitor these parents. I understand they've got a long history. I'd understand why the court would want to continue to see longer periods of sobriety, but to not find them in compliance, I don't think is a fair assessment of the time, effort, and energy these parents are putting into addressing the issues and committing themselves to their services.
And Your Honor, I would mirror Ms. Savage's remarks and also add there were extenuating circumstances the past couple of months with the issue that Ms. Kuykendall had. She was in the hospital. Belong has mentioned that they're not using the time that she wasn't engaged in services to address those issues against her. And so I would also ask that they both be held in compliant, that they're in compliance.
Thank you. Mr. McKeska, any rebuttal?
No, Judge.
I do, Judge.
Go ahead.
Just, Your Honor, that I absolutely recognize what all the parents are doing. However, one of the requirements of the service plan is to consistently maintain a safe, stable, drug and violence-free home. And I understand that only Ms. Kuykendall admitted to a relapse, but he's a team. Mr. Castro is a team with her. They're doing this together. And if one person in the house is relapsing and they're not admitting to that and putting safety measures into place immediately without a drug test, then they are not maintaining a safe, stable, drug and violence-free home for their child. That's why I would argue they're in partial compliance.
I want to get something clarified real quick before I make a ruling. Ms. Harris, what was the exact reason that the relapse prevention plans weren't created?
What was the reason for what? I'm sorry?
I ordered that the relapse prevention plans be created between Belong, the parents, and the counselors at MHDD back on January the 10th. And I'm wondering what was the exact reason that wasn't done?
Due to the birth of Arrow, they had taken a break from those services. So when they return on March 8th, that should be addressed then.
Okay, that was my understanding, but I just wanted to make sure there wasn't some other reason outside of the birth of the child. Okay, as far as the motion to retain is concerned, there's no opposition to it. Court finds, based on the testimony of this and the circumstances of this case, that extraordinary circumstances necessitate the child remaining in the temporary management conservatorship of the department. and and the continuation of the appointment of the department as temporary managed conservator is in the best interest of the child. Court will retain the suit on the court's docket for a period of 180 days. The next dismissal date is going to be, or the new dismissal date, is November the 9th, 2024. November the 9th, 2024. The permanency hearing scheduled next is June 5th, 2024 at 10 a.m. It's June 5th, 2024 at 10 a.m. And our final trial is going to be September the 4th, 2024 at 10:30. Court finds for the purposes of the permanency review today, the permanency goal is relative fictive kid adoption with a concurrent goal of family reunification. Court finds there's no Indian child heritage in the suit. The current placement is safe and appropriate, meeting Atlas's needs and his best interest to continue. Court finds that he's up to date on all his checkups. Court finds that no requested changes have been made to the visitation schedule and that the current visitation schedule is appropriate. I'm going to find that both parents are in compliance, but I am going to also find on the record that I'm concerned about the relapses considering the history. I understand CASA and Ms. Harris's concerns, but I also agree with Ms. Savage and Ms. Acosta that relapse is a part of recovery, especially when you've got a significant drug history. But that being said, Ms. Kuykendall and Mr. Castro, it's not an excuse to keep doing it throughout the course of this case.
Yes, Your Honor.
If you're fighting it and you're getting the help you need, that's one thing. If we're just relapsing and we're getting into another pattern of drug use, that's another. As I heard the testimony, one of the relapses was 60 days ago and the other one was back in October. So it's been a significant period of time. But I'm concerned that those plans weren't made. And the reason I want to make sure I understood why was the birth of the child. That needs to happen. Ms. Harris is right. That needs to happen now, like immediately.
I agree.
And that I'm ordering Belong again and the parents and their attorneys to get with the counselors and MHDD, create those relapse prevention plans within the next 7 days. Figure it out. And if you can't, if there's some scheduling issue that we can't get it done in a week, I need to know about the scheduling issue.
Yes, sir.
And let's see. Our next hearing, as I said, is June 5th, 2024 at 10 a.m. I'll find that the child is, I think I said he's already up to date on everything. I think I already made that finding. So I have to admonish the parents. We've got an extension in this case, so you have more time. Normally, the state of Texas gives parents in these cases 12 months to demonstrate you can provide a safe, stable, violence, and drug-free home for your child. You're getting 18, but it's going to end. It's not going to last forever. And if we get deep into this next 6-month period and we're still having relapses, we're still having problems, that's going to be a problem.
Yes, sir. Yes, Your Honor. There's not going to be no more problems. We're working on that ourselves.
All right. Mr. McKeska, is there anything I failed to address?
No, Judge.
Okay. Thank you all for your time and your service. Good luck to you, parents. If nothing further, all parties are excused.
Thank you, Your Honor.
Welcome. 198th Judicial District Court of Kirk County. Court is streaming outside of Kirk County for purposes of this suit. Is there any objection?
No, Your Honor.
No, Judge.
With that, Mr. McKeska, would you please begin the announcements? And if each of the attorneys could please prompt their clients to announce.
Well, yes, Judge. Drake McKeska, attorney for the department. Mr. Minen.
Blaine Minen, permanency specialist with Belong.
Lindsay Ligon, permanency supervisor with Belong.
Goldie Robson, Hill Country CASA, guardian ad litem supervisor.
Reva Johnson, guardian ad litem CASA volunteer.
Kathleen Savage, attorney for the respondent father, Mr. Stinson, not ready, Your Honor, no contact.
Deborah Fuller, attorney ad litem for the children, Your Honor, ready.
Jennifer Harris, attorney for the mother, Ms. Shamout, will you please unmute and announce your name?
You're unmuted, ma'am. You can go ahead and announce.
Okay, Juliana Shamote.
Maureen Yanis, attorney ad litem for Brandon Sharp.
He is present. Mr. Sharp, will you unmute and announce?
It's Brandon Sharp.
Mr. Sharp, if you could please keep your device still, set it down somewhere because you're shaking a lot and it's hard for me to watch. I'm sorry. All right. Mr. McKeska, do you know if you ever got service on Mr. Stinson?
Judge, I don't believe we were or have received any executed citation. I know that we went through the process to achieve international service in Italy, but that is it's a lengthy process, unfortunately. However, based on the progress of the mother in this case, at least with regard to Pinwheel, we would be asking for the department or for the court to dismiss the department's petition.
Okay. In toto, we're dismissing the whole thing.
With regard to Pinwheel, I do believe that there are probably some final orders that are necessary with regard to Otto. But with regard to Pinwheel, with Mr. Stinson being alleged father, there's also a pleading for an unknown father. The children being back in the mother's care without concern. Yes, we'd be asking the department or the court dismiss the portion of the department's petition with regard to Pinwheel.
Okay. Any objection to Mr. McKeska's position?
No objection.
No, Judge.
No.
I have no objection. I just wanted confirmation though that they didn't have service because I heard that the right people had the document. So I feel like orders would be appropriate in this case, but I just, I haven't seen any confirmation that there was no service.
Right. The last update we received is that the central authority in Italy had received all the documentation, and they would be the ones that would execute service for us in Italy. However, we have not received anything back from the central authority confirming that he has in fact been served.
And no objection.
Okay, thank you. Yeah, I'm looking at it. Our dismissal date is May 27th, so we have a little bit of time, but I think if Ms. Chameau is in compliance and the kids our child is safe with her, and there's no objection otherwise, then I could understand the desire to have those orders in place, but I just don't know that we're going to get service in that time. I don't really want to extend the case. So in that sense, I don't see any point in delaying the inevitable. So I'll grant that request. I don't think I've sworn anybody yet. Anybody who's not an attorney or will be giving testimony, please. You believe that this severance and dismissal as to Pinwheel and Ms. Chameau in that sense is in the best interest of the child?
Yes, I do.
All right. Ms. Fuller, I know you want orders, but do you believe that notwithstanding that, that a dismissal for Pinwheel would be in the best interest of the child?
Yes, Your Honor.
Okay. And then CASA, Ms. Johnson?
Yes, Your Honor.
All right. Then I'll grant that request. And as to the child, Pinwheel, the court will sever out and dismiss all issues relating to that child, and we'll continue on with the case on Otto and Mr. Sharp. In that sense, Ms. Savage, who represented Mr. Stinson, is dismissed, and the court will make a finding that she has satisfactorily performed her duties in this case. So Ms. Savage, you are excused from the remainder of these proceedings. And I think that's the only person that is done in this particular case, correct?
Yes, Judge.
Okay, so then with that, let's go ahead and proceed as to Mr. Sharp and Otto's case, and Ms. Chameau. What were the parties intending to do today on that particular part?
Judge, I know that Ms. Harris had previously circulated a proposed order, proposed agreement regarding Otto. So I would ask if we could, the attorneys just have in CASA, have a brief breakout room to see where we are on that proposal.
Okay, I'm gonna hold you to that brief thing. So many cases on the docket today. And I think the next case that we have on the docket is going to take at least an hour or so. Or it's going to take an hour. All right, so you want Ms. Harris, Casa,
Ms. Fuller,
and
Ms. Young.
Not here anymore. All right. How do the parties wish to proceed?
Judge, I believe that we are close to being able to reach an agreement regarding a final order. There's some issues that have to be, I think, ironed out. And so in order to be able to do that, we are going to ask the court to reset this portion of the case and allow us to mediate next Wednesday afternoon to be able to iron out those details.
Anybody in objection to that?
No, Judge.
No, Judge.
It's done. I'll reset it. Ms. Greenlee, what's our date to come back after they mediate next Wednesday?
March 20th at 9:30.
Anybody going to be out of the country on a beach somewhere in a trial?
Your Honor, I'll be in a jury trial, but I'll get somebody to cover.
Okay. Ms. Fuller, I need you to check your litigation calendar and your cruise calendar, please. Is everybody available on the 20th at 9:30?
Yes, Your Honor.
Okay.
Yes.
Then the request of the parties and the agreement to reset is granted. All orders previously in place will remain in effect. We'll be back for final trial March 20th, 2024 at 9:30. Before I call the case, my understanding is this is going to be contested.
Yes, Your Honor.
Mr. McKeska, would you please begin the announcements? And if the attorneys could please prompt their clients to announce.
Yes, Judge. Drake McKeska, attorney for the department. And let's start with Ms. Peterman.
Ashley Peterman, Child Protective Investigations.
Irene Acosta, attorney ad litem, appointed to represent the mother, Blake Kuykendall. Ms. Kuykendall, can you please unmute and announce?
Hi, my name is Blake Kuykendall. I'm the mother.
Kathleen Savage, attorney for the respondent father, Jamie Castro. Mr. Castro, if you can announce your name for the record.
I'm Jamie Castro. I'm the father of Arrow.
Okay, all right.
Jimmy Dresden Mitchell, investigation supervisor.
Christine Ligas, CPI investigator out of Travis County.
Jennifer Harris, attorney ad litem for the child. I'm ready.
Goldie Rabson, Hill Country Casa, guardian ad litem. Stephanie, you can go ahead and announce.
Stephanie Goss, Hill Country Casa.
Down now. All right. Any housekeeping issues we need to take up before we proceed?
I don't believe so, Judge.
All right. Then with that, everybody waive opening?
Yes, Judge.
All right. You may proceed, Mr. McKeska.
Thank you, Judge. I'd like to call Ms. Kuykendall as my first witness.
All right. Ms. Kuykendall, you've been sworn. Mr. McKeska is going to ask you some questions. Answer the question he asks you, and don't answer any other question unless you're asked. Okay, go ahead, Mr. McKeska.
Yes, Your Honor.
Thank you, Judge. Ms. Kuykendall, can you please state your name for the record?
Blake Kuykendall.
Okay, and you're Arrow's mother, correct?
Yes, sir.
Okay, and when was Arrow born?
January 2024.
Okay, I understand you had some complications with his birth. Is that correct?
Yes, sir.
Okay, what sort of complications did you have?
Arrow's placenta, the placenta grew into my bladder, and I had to go into emergency C-section. I was taken by ambulance from Fredericksburg Hospital to Austin, and I was in surgery for 8 to 10 hours.
Okay, and when were you admitted to the, let me scratch that. Which hospital did you first go to?
Fredericksburg Memorial Hospital.
Okay, and when were you admitted to Fredericksburg?
January 8th, right? January 8th, yes.
Okay. And were you drug tested whenever you were admitted to the hospital?
Yes, sir.
Okay, and were you positive for
Your
methamphetamines?
Honor, I'm going to object to hearsay.
Overruled.
So Ms. Kuykendall, you can answer my question. Do you test positive for methamphetamines?
Yes, sir, I did.
Okay. When did you use methamphetamines?
3 days prior.
Okay, so approximately January 5th.
Okay, hang on. Ms. Kuykendall, you can't get answers from Mr. Castro.
Yes, sir.
If you don't know the answer, then say, I don't remember or I don't know. Okay, go ahead, Mr. McKeska.
Thank you, Judge. So was that approximately January 5th?
Yes, sir.
Okay. And how did you obtain the methamphetamine that you used?
A friend of mine came over and I was in a lot of pain. I was basically, I had blood clots and I was coughing up blood, spitting up blood, and anyway, I was in a lot of pain and she had offered it to me and I took 2 hits and I felt better, but I knew it was a mistake.
Okay. The friend that you called, did you identify her by the name of Sam?
Yes. Yes, sir.
Okay. And why did you call Sam specifically?
I didn't call her. She showed up to check on me. She had heard that I had been in bed for a few days from bleeding and she was coming to check on me.
Okay. If you were in pain and you were bleeding, as you described, why didn't you go to the hospital earlier?
I really don't know why I didn't. I was scared, honestly. I was only 33 weeks pregnant, and later, after the fact, I realized I had made a mistake, and we had decided to go to the hospital.
Okay. And you've had previous children removed by the department, correct?
Yes, sir.
And they've been removed for methamphetamine use?
Yes.
Okay. And in fact, you have another child who's currently in the temporary managing conservatorship of the department, correct?
Yes, sir.
Okay. And Atlas was removed for methamphetamine use?
Yes, sir.
Okay. And during the course of Atlas's case, you've been provided services to address your drug treatment. Is that correct?
Yes, sir.
In the cases prior to Atlas's case, you've also been provided services for drug treatment, correct?
Yes, sir.
Okay. On around January 5th, why didn't you utilize the tools that you've learned in your drug treatment to not use methamphetamine?
To prevent my use.
Right.
In a stressful situation, I was in a lot of pain. It was a mistake and I learned I didn't continue to use. So, but I see your point. I should have called my sponsor. I should have reached out to somebody and told them what was going on. And I was just desperate, I guess.
Okay. And
honestly,
after being in pain and bleeding, did you feel that there was something medically wrong with you?
The beginning of the pregnancy, I was bleeding. I had a hematoma and the doctor said it was normal, that it would go away. So I thought the bleeding was normal, and coughing up blood, I didn't think that was normal, but I just didn't know if it was a concern or not. Jamie was at work, so I didn't really have anybody. Well, I guess I could have called somebody, but I didn't really know for sure what to do. But I know I should have called somebody or reached out for help or just gone to a hospital. I understand that.
Okay. And not use methamphetamine, correct?
Yes, you're right. Obviously.
Pass the witness, Judge.
Mr. Colston.
Ms. Kuykendall, have you used since then?
No, I have not.
And have you been maintaining your sobriety?
Yes, I have.
And after the pause in the services that were provided to you, have you re-engaged in all of those services?
Yes, ma'am.
Okay. And so at this point in time, your engaged in all of the services that are being provided to you, and you're maintaining your sobriety, correct?
Yes, ma'am. I'm in closer contact with my sponsor, more so now than I ever have been. And the services that I have been working this past year has made a huge difference in my life. I just wanted to add that. I feel like I've made a huge difference now than I have worked in my other cases. And I feel like the services are working for me, and I appreciate that.
And are you currently getting to see Arrow?
We saw him at the CPS office last Tuesday. So I've seen him once since he's been out of the hospital.
I'll pass the witness. I'll pass the witness, Judge.
Ms. Savage and Ms. Kuykendall, I'm going to remind you, just answer the question that you're asked, okay? Don't.
Yes, sir. Sorry.
Go ahead, Ms. Savage.
Ms. Kuykendall, the use on January 5th, that was a single time relapse, is that correct?
Yes, ma'am.
Okay. And since then, you've submitted to all the drug testing required by Belong?
Yes, ma'am.
And your hair test was negative?
Yes, ma'am.
Okay. And when the investigators reached out, were you honest about the usage and the relapse?
Yes, ma'am.
Were you cooperative with DFPS investigators?
Yes, I was.
And did you meet with them?
Yes, ma'am.
And did you provide them appropriate safety plan people who could help supervise your contact with Arrow to address their concerns?
Yes, ma'am.
And that was the Strunks, correct?
Yes, ma'am.
And would you be allowed to live with Arrow at the Strunks home who could supervise your contact?
Yes, ma'am.
And the Strunks could ensure that you and Mr. Castro remain sober around Arrow?
Yes, ma'am.
Are you asking the court today to deny the department's request for removal and to allow you and Mr. Castro to remain with the Strunks and Arrow in your care?
Yes, ma'am.
And would you ask the court to order an MTP if the court wanted to continue to monitor your progress as it relates to Arrow?
Yes, ma'am.
And are you willing to engage in services through an MTP for the department?
Yes, ma'am.
And that would be in conjunction to your case with Atlas, is that correct?
Yes, ma'am.
Okay. And you're willing to continue to engage in drug treatment so that you can remain sober?
Yes, ma'am.
Okay. I'll pass the witness, Your Honor.
Ms. Harris.
Ma'am, do you and Mr. Castro live together?
Yes, ma'am. Currently, yes.
Were you in that home when your friend came over with the drugs?
Was I in the home? Is that what you said?
Yes, the home that you share.
Yes. He was at work.
Through all of the services you've obtained and the training you've gotten, do you think it's appropriate to continue having contact with people that use drugs and provide you with drugs?
Absolutely not.
Did you tell Mr. Castro when you used?
Not at that moment, but I did tell him.
When did you tell him?
On our way to the hospital. I was afraid of him relapsing also.
When did when did Arrow get out of the hospital?
It was, I believe it was January 27th. Can't ask you. I think it was January 27th.
Okay. And
not January 27th. February 27th, I'm sorry.
And do you think it was dangerous for you to use methamphetamines while you were pregnant?
Yes, of course I do.
Do you think it was especially dangerous because you were a high-risk pregnancy?
Yes, ma'am.
How many other children have you had removed because of drug use?
I believe 7.
No further questions, Judge.
Rebuttal or follow-up, excuse me, Mr. McKeska?
No, Judge.
Anybody have any other follow-up questions for Ms. Kuykendall?
Just one, Your Honor.
Go ahead.
Ms. Kuykendall, did the department attempt to return Arrow to you?
Not that I'm aware, no.
Okay, so there was never any offer to have any kind of parent-child safety placement put into place where you're living with someone and the child stays with you, supervised with that person?
I wasn't given any options, no.
Okay, so their first reaction was to just remove Arrow when he was released from the hospital?
Yes, ma'am.
Okay, I'll pass the witness, Judge.
I do have follow-up after that, Your Honor.
Go ahead.
Ma'am, have the department been offering you services in your companion case?
What's a companion case? Sorry.
In your other child's case that's pending?
Yes, ma'am.
And what are those services that they've been offering you?
I've been attending a drug treatment program once a week. I also see another counselor once a month through MHDD. We completed parenting and the Phoenix program, and I go to NA, and so far I think that's it.
And did you begin all of that before Arrow was born?
I've been doing it for almost a year now. Yes, ma'am.
And were you doing it after Arrow was born?
I was supposed to take a pause in my classes. They told me 2 months, but before the 2 months was up, I asked my caseworker if I could continue with my services.
Okay. And what was the pause for?
The pause was for the birth of my son and the complications.
And has the department had all those ready for you to go to be able to start back again?
Yes, ma'am.
No further questions, Judge.
The next witness, Mr. McKeska.
Thank you, Judge. I'd like to call Mr. Castro.
All right. Mr. Castro, Mr. McKeska is going to ask you some questions. Remember, you're under oath. And
yes, sir.
Question that you're asked. Don't elaborate on anything that you're not asked.
Okay, Mr. Castro, can you please state your name?
Name's Jamie Castro Jr.
Okay, and you're Arrow's father, correct?
Yes, sir. Yes, sir.
Okay. Have you been honest with the department through the course of this investigation?
Yes, Your Honor. Or yes, sir.
Have you told the department that Ms. Kuykendall actually didn't use, that she was just scared and so she admitted to using because of her fear?
I did.
So let me ask you again, have you been completely honest with the department during the course of this investigation?
With everything but that.
So the answer would be no, is that correct?
Yes, sir.
Okay. Do you think honesty is important considering these circumstances?
Yes, it is.
Okay. And through the course of the companion case with Atlas, part of your family plan of service is that you're going to be open and honest with your service providers in the department, correct?
Correct.
Okay. So why did you lie to the department?
I guess because I've been doing so well and placing our son into a home I don't believe is safe for him. And other than that, I really don't know, you know, except for I wanted my son.
Okay. Why do you think that honesty is important?
Well, I think it's important so everything's out on the table and it shows that we're doing what we're supposed to be doing and that we can be open and honest, whether we relapse, whether we're doing the right thing, whether we do wrong, just so we take ownership in our actions and what we do.
Okay. And in fact, Arrow's your third child that's been removed by the department, correct?
Yes, sir.
Okay. And your older two have been removed or were removed because of methamphetamine use, correct?
Yes, sir.
Okay. Pass the witness, Judge.
Mr. Costa.
Mr. Castro, when Arrow was removed, did the department reach out to you and offer you a safety plan?
Well, when Arrow was removed, we found out the day before.
Come on, Mr. Castro.
No,
Yes
they
or no?
didn't.
Okay.
No.
And did they offer to have him placed with you with family members or to be supervised with him?
They just asked for contacts and that's it.
How often have you been in communication with the department regarding Arrow?
Just once when we had our visit last week.
Okay, and did they reach out to you to inform you that he was being removed?
No, ma'am. My attorney reached out to me after he was removed.
Okay. Currently, you're working on services in another case, correct?
Yes, ma'am.
And are you up to date on everything in those services?
Yes, ma'am.
Are you actively engaged in all of those services?
Yes, ma'am.
Okay. And would you be requesting that Arrow be allowed to remain with you and Ms. Kuykendall in potentially a motion to participate, but not in a removal proceeding?
Yes, ma'am.
And do you believe that right now you are able to continue working services and maintain sobriety while having your child placed with you and Ms. Kuykendall?
Yes, I do.
I'll pass the witness, Judge.
Ms. Savage.
Mr. Castro, you have not relapsed since October, is that correct?
Yes, ma'am.
So you've been clean at least the last 6 months, correct?
Yes, ma'am.
And your recent hair test that you were able to submit to further substantiated that you are sober?
Yes, ma'am.
So you also could have been a supervisor for Blake given her recent relapse, correct?
Yes, ma'am.
But did you offer the department another layer of protection when you offered the Strunks to supervisor contact with Arrow?
Yes, I did.
And the department's response as to why they would not consider the Strunks, do you recall what they told you?
The only thing that was in the paper was they wanted to put him with siblings and that they had their medication on the table. And that's why they denied their home.
Okay. Was it because the department believed the Strunks were too elderly to supervise your contact with Arrow?
Objection leading.
Sustained.
Is it your position, or would you be asking the court to grant an MTP today?
Yes, ma'am, I would.
Okay. And are you willing to have your contact supervised by the Strunks?
Yes, ma'am.
Okay. And we just had a hearing for Atlas's case. What was the court's ruling on your compliance and your services?
That I was in compliance.
And are you willing to continue to engage in those services?
Yes, ma'am, I am.
And are you willing to continue to drug test for the department?
Every week, yes, ma'am.
I'll pass the witness, Your Honor.
Ms. Harris.
Sir, were you aware that somebody came over to your house with drugs?
No, I was not.
And were you able to tell that Ms. Kuykendall was under the influence of drugs when she used on the 5th?
I had my suspicions, but at the same time, everything was pointing to no.
Okay, so if you had your suspicions, what did you do?
I asked her, but she told me that she was not.
And you didn't think it was more important to maybe ask her more than once or take her to the hospital if you had your suspicions and she's in a high-risk pregnancy?
Yes, ma'am. And 2 days later, when the bleeding got worse and she actually told me that she was bleeding and coughing up the blood, I made her go to the hospital. And that's why we went, because I told her, what's more important, your life and the baby's life, or something happened?
So you thought it was important enough to take her to the hospital when she was bleeding, but not important enough to take her to the hospital when you thought she might have used drugs?
Like I said, she told me she didn't, and I had my suspicions, like I said, but at the same time, when she laid down and went to bed, you know.
And when she admitted that she had used, did you call the department and let them know, or did you wait until the drug test results came back?
Well, I waited until the drug tests come back. I was on my way to the hospital with her. I had to get her to the hospital, and then
when you relapsed in October, did you let the department know before you tested positive, or did you wait until the drug test results came back?
I waited till the results came back, and when they asked me, I told them straight up.
And you actually offered the Strunks as a possible placement for your other child, correct?
Yes, ma'am.
And you identified them as support for you and Miss Kuykendall?
Yes, ma'am.
So they've been in your lives all this time and they've been your support. How have they prevented you from, I'm sorry, let me rephrase that, Your Honor. You relapsed in October and she relapsed in January, even though the Strunks have previously been identified as your support system, correct?
Correct, but we don't live with them. And they were both one-time things
where... hang on. Mr. Castro, I'm telling you for a third time. She's going to ask you a question. If it's a yes or no question, you say yes, you say no. If it's an open-ended question, you only give the information she asked you for. If you keep elaborating on every single answer, we're going to be here all day, and I don't have all day. Okay?
Yes, sir.
Yes or no, or a short answer. Go ahead, Ms. Harris.
Is October the only time that you've relapsed on using methamphetamines?
Yes, ma'am.
You never relapsed before that, before this case, before another case?
Years ago, yes, ma'am.
Okay. And I think the testimony was that you also took a break from your services after the birth of the child, correct?
Correct.
Why is that?
Well, traveling back and forth to Austin and working.
Okay. So are any of your services virtual?
No, ma'am. One's over the phone.
One's over the phone. Which one is that?
That's my counseling every Wednesday.
Okay. And did you keep doing that?
Yes, ma'am, I did.
Okay. And what about AANA meetings?
I stopped going, but I have attended 2 since we've been back.
Okay. And you didn't think that it was especially important to be going to those after there had been a relapse in your home?
Well, I really had no time, ma'am. Our son was in the NICU, and every moment that we had extra or that I was off, which was a lot of days during the week, I took off so we could stay up in Austin to be with our son.
Are there meetings available in Austin?
I'm sure, but I don't know where.
So you said that you offered to have the Strunks be a support so that Arrow would be able to live with you guys. Did you provide them any other names when they said that they could not approve the Strunks as a safety plan?
Yes, my mother.
Okay. And does she have any criminal or CPS history?
She has a CPS case that was dismissed from over, I believe, 15 years ago, and no criminal history at all.
Where does she live?
She lives in Comfort, Texas.
And is there a reason that you wouldn't? Never mind. No further questions, Your Honor. I'll pass the witness.
Any follow-up, Mr. McKeska?
Just briefly, Judge. Mr. Castro, there's some testimony regarding the hearing that we had earlier today for Atlas's case. Was Atlas returned to your care?
No.
Okay. And that case was extended so you can continue to engage in services to address these concerns, correct?
Yes, sir.
Okay. Nothing further, Judge.
Any further questions for Mr. Castro? And I'll remind you, we're running low on time.
Yes, Mr. Castro, the difference between the Strunks being supports and what you're asking the court to order today is that you guys would be living there. Is that correct?
Yes, ma'am.
Okay. So the Strunks, at the time of Blake's relapse, you guys were living on your own, just you and Blake.
Yes, ma'am.
Okay, but you're asking the court to order Arrow be returned to you with you and Blake in the Strunks home.
Yes, ma'am.
I'll pass the witness, Your Honor.
Next witness, Mr. McKeska.
Judge, I'd like to call Ms. Peterman. Okay. What is your role with this particular case?
With this particular case, I was assigned it from the county that it was originally opened in. So I was a secondary assignment, but I currently am primary on the case.
Okay. And you became primary because the parents reside in Kirk County, is that correct?
Yes, sir.
Okay. When did you become the primary caseworker for the case?
January 18th, 2024.
Okay. And whenever you became the primary caseworker, did you review the investigation that had been completed up until that point?
Yes, sir.
Okay. And were you aware of the allegations that came into the department that opened the investigation in the first place?
Yes, sir.
Okay. What were the allegations the department received?
The allegations were neglectful supervision of Arrow.
Okay. And what was the reason or the concern for the neglectful supervision?
There were concerns of a drug test that was done upon admission to the hospital.
Okay. Can you elaborate on that for me?
Yes, sir. The report came in stating that Ms. Kirkendall had tested positive for methamphetamines upon admission to the hospital.
Okay. Since becoming the primary caseworker, what steps have you taken during the course of the investigation?
When I became primary in the case, January 18th, I reached out to Ms. Kirkendall to verify the names that she had provided to the Travis County worker, and she did identify Carlene Martin, Gary, and Virginia Strunk, as well as Diana Dowertree as options for Arrow.
Okay.
She was not able to, I'm sorry.
And whenever you say options, was that as a PCSP, as a safety plan? What was that?
That was nothing specified. I believe I referred to it as safety intervention, not specifying to a safety plan, parent-child safety placement or anything.
Okay. And so were you able to look into those various safety interventions?
Yes, sir.
Okay. Who was the first safety intervention that you looked into?
We looked into Miss Carlene Martin.
Okay, and that's the paternal grandmother?
Yes, sir.
Okay, and was it determined that she was able to be a safety intervention?
It was determined that she was not able to be.
Okay, why could the paternal grandmother not be a safety intervention?
Due to concerns with her history with the department, as well as her own prior history with Mr. Castro and Ms. Kirkendall regarding their children's safety.
Okay. Has she been involved in the previous CPS cases?
To my understanding, yes, sir.
Okay. So what specifically were the department's concerns regarding her ability to be a safety intervention?
The concerns were that she has displayed a prior history of working with the families to avoid the department and not provide accurate information that would allow us to ensure the safety of the children.
Okay. Who was the next safety intervention that you looked into?
Gary and Virginia Strunk.
Okay, and what steps did the department take or did you take to evaluate them for a safety intervention?
I reached out to Miss Strunk and kind of reviewed with her that we were involved and that we did not have any information at this time, but discussed with her her willingness to be able to be a safety intervention for Mr. Castro and Miss Kirkendall. She did identify that she would be willing to, but when I asked her about long term, she did identify at the time that maybe a month or so, and did ask about if Blake would be able to
be present as well to assist with the care of the baby. And then on a later date, I had a coworker reach out and kind of talked with her a little bit about what expectations would be if a safety plan were implemented. And that was when we explained that the family would need to move in, or that the Shrunks would need to move in with the family. It's my understanding that she was not she did not confirm or deny at that time. She said that she would reach back out. I was not advised by my coworker that she reached back out.
Okay. Have the Shrunks been previously considered in other cases?
To my understanding, yes, sir.
Okay. And do you have any knowledge of why they weren't utilized in those other cases?
Yes, sir.
Okay. And what is your understanding of why they weren't utilized in the other cases?
My understanding of why they were not utilized is due to medical concerns that they had ongoing at the time.
Okay. Do you know if those medical concerns are still at issue?
To my understanding, per Mrs. Strong, they have addressed those issues and have reported that they are no longer ongoing concerns.
Okay. Did the department evaluate the Shrunks home?
One of my coworkers did, yes, sir.
And was the home approved as an appropriate home or as a safety intervention?
The home itself was appropriate. However, there were some concerns that would need to be remedied before an infant could be placed in the home.
Okay, and what were those concerns?
There were concerns that there were choking hazards throughout the home, as well as medications out in the open.
Okay, and were those concerns addressed with Mr. and Mrs. Strunk?
To my understanding, yes, sir.
Is there another individual that was evaluated as a safety intervention?
Diana Dougherty was identified as the last one, and she is a licensed foster home.
Okay, and what is her relation to the parents?
She is the adoptive mother of Mr. Castro's daughter, as well as the current foster placement for her sibling Atlas.
Okay, and due to her being the foster mother for Atlas, she wouldn't be able to serve as any sort of safety plan for the parents. Is that correct?
I apologize. You cut out. Could you repeat the question?
Yeah, since being that she's the foster placement for Atlas, she wouldn't be able to be the safety intervention or the safety plan allowing the parents to move into her home. Is that correct?
Yes, sir.
During the course of the investigation, the parents have been provided services through the companion case with Atlas. Is that your understanding?
Yes, sir.
And do you know what services they've been offered?
I am aware of the services that were told to be by Miss Harris, the belong caseworker.
Okay. Did you consider whether or not a parent-child safety placement would be appropriate for this case?
That was something that was discussed as an intervention, yes, sir.
And what was the determination regarding a parent-child safety placement?
The determination was that it was not appropriate.
Okay, and why wouldn't a PCSP be appropriate in this case?
A PCSP would not be appropriate due to the Texas Family Code only allowing a parental child safety placement to last for 30 days with additional extensions.
Your Honor, I'm going to object. So this client's reading off of something. She keeps looking off. I don't know what she's reading. I haven't provided it.
Ms. Peterman, what are you reading?
I'm reading my affidavit, Your Honor.
This is the affidavit that's been provided to all the parties in this case.
Yes, sir.
All right, overruled. Continue.
So with 2 extensions up to 30 days, and it is not believed that that is a sufficient amount of time to be able to address the concerns that were noted in the case.
Okay, and why don't you believe that 90 days would be a sufficient amount of time to address these concerns?
I'm sorry, could you repeat that?
Sure. Why do you believe that 90 days would not be a sufficient amount of time to address the concerns in this case?
Due to substance use being an ongoing concern, and due to the family's history, as well as receiving services that were discussed by Belong, as well as the concerns from Belong as well regarding the services completed.
Okay. Pass witness, Judge.
Ms. Acosta.
Ms. Peterman, you stated that you were reading off of the affidavit where you were discussing PCSPs lasting however many days. Can you tell me on what page of the affidavit it states that?
It is listed under Section 5, reasonable efforts to prevent or eliminate a removal. It is the second paragraph.
Under Section 5?
Yes, ma'am.
And you're saying that that's the section wherein it states that a PCSP wasn't implemented because the Texas Family Code only allows however many number of days for that parental child safety placement to take place? Would it surprise you to hear that I'm looking at it right now and I don't see that mentioned anywhere in the second paragraph? I'll move on, Judge.
Yes.
You mentioned that another caseworker spoke to Ms. Strunk. As the primary caseworker on this case, why didn't you reach out to Ms. Strunk to see whether or not she could provide a safe environment for Arrow and supervise the parents?
I do not have a satisfactory answer for that.
Do you have any answer for it?
Just because one of my colleagues offered to assist me.
Okay, and which colleague was that?
Initially, it was Stacy Turner.
And you said initially it was Stacy Turner. Who was it after that?
The investigator that assisted me with the home visit was investigator Kara McElhenney.
Okay. So have you spoken to the Strunks?
I had spoken with them once, with Ms. Strunk once over the phone.
Okay. And did they tell you that they were willing to supervise Ms. Kuykendall and Mr. Castro with Arrow? It's a yes or no question.
Yes, ma'am.
Okay. And so when did they tell you that?
I do not recall the date.
Was it before Arrow was released from the hospital?
Yes, ma'am.
Okay, so prior to Arrow being released from the hospital, you had identified someone who was willing to supervise the parents with Arrow. Is that correct?
Yes, ma'am.
The concerns that were found in the Strunk's home, you said that they were choking hazards and medication left out in the open. Is Arrow old enough to move around on his own?
From what I've observed of him, no, ma'am.
Okay. Is he old enough to access medication bottles that are left out in the open?
No, ma'am.
Okay. So both of those issues could have easily been resolved in a reasonable amount of time. Is that correct?
Yes, ma'am.
Is the only reason Arrow wasn't allowed to be in the home with the Strunks and Mr. Castro and Ms. Kuykendall because they have an ongoing case with another child?
I'm sorry, could you repeat that question?
Yes. Is the reason that Arrow was not allowed to go home to their parents while being supervised with the Strunks, is the only reason that wasn't allowed to happen the fact that they have another case open?
No, ma'am, not to my understanding.
Why wasn't Arrow placed with the parents in the home of the Strunks?
The home of the Strunks, there were additional concerns for their ability to provide safety and long-term permanency for Arrow being present, as well as due to the fact that they do still have some medical needs, and at the time it could not be approved.
Didn't you just testify earlier that Ms. Strunk had stated that the medical issues that they previously had in prior cases have since been resolved?
The immediate concern in the prior case, yes, but that is not to say that there are not ongoing medical issues that are being addressed.
Okay. But did you not testify earlier that Ms. Strunk said that the medical issues that they had previously are no longer an issue?
Yes, ma'am.
Okay, so currently there's no medical issues barring the Strunks from providing support and supervision for Arrow and his parents.
No, ma'am.
Okay, I'll pass the witness, Judge.
Savage, it's 12:31. I'm gonna have to cut this off at 12:40. If we
I'll
can
make it.
if we can't, we can't.
I'll make it very quick, Your Honor. Ms. Peterman, you were testing out family safety plans being only 30 days, but actually it's accurate that those can be extended even beyond 90 days when parents are represented by counsel. Isn't that true?
I was not aware of that. No, ma'am.
Okay, so you're testifying to the law, but you're not fully aware of what that law is. Is that correct?
Objection, argumentative.
I'll rephrase. You are aware that the parents were represented by counsel at the time that you met with parents. Is that correct?
Yes, ma'am.
Okay, and we actually met February 6th, and the Strunks were at that meeting. Is that correct?
Yes, ma'am.
And at that time, they advised you that they were willing to have the parents in the home and were willing to supervise 24-hour contact between the parents and Arrow. Is that correct?
Objection, Your Honor. Calls for hearsay.
Your Honor, she was there. And the Strunks are here too.
And Your Honor, Ms. Peterman opened the door when she started testifying as to what the Strunks told another worker.
Overruled.
Ms. Peterman, you can answer.
Okay, yes, ma'am. I was there and I was aware that they said that. Yes, ma'am.
Okay, so for the last 30 days, the department could have worked with getting Arrow placed with the Strunks and the parents in that home. Is that correct?
Yes, ma'am.
Okay. And as far as what efforts you made to prevent removal, what efforts, if any, did you make to prevent removal? Since we know you didn't try to place the child with the Strunks.
Objection to sidebar and argumentative.
What efforts did you make, Ms. Peterman, to prevent removal?
I did speak with the Strunks, as well as having a coworker assist me with evaluating their home and providing the information to my supervisor and regularly staffing with Belong regarding concerns and regarding services that parents were currently working on.
Okay, but you didn't offer any services. Did you drug test the parents?
Yes, ma'am.
And so you're aware that the parents are sober?
I am aware that they have had negative tests. Yes, ma'am.
Okay, so we're talking about removing a baby from parents when only one parent tested positive over 60 days ago, correct?
Yes, ma'am.
Okay, and per your testimony with Ms. Acosta, the department does have the ability to open a family-based plan if this court were to order NCP today. Is that correct?
I am not entirely sure of that.
Okay, so, but if this judge does order an MCP, the department would offer services and would work with the parents. Is that correct?
We would do as the judge orders. Yes, ma'am.
Okay, I'll pass the witness.
Mr. McKesko, any other witnesses that you can get through in the next few minutes?
Just I believe Ms. Harris would have the opportunity to cross Spearman.
That's right. Ms. Harris, go ahead. No apologies.
I'm okay, Your Honor. I'm good. No questions, Judge.
Okay.
Judge, given that we've got about 5 minutes left, I don't think I'd be able to get through the next witness.
Okay. And what I'm looking at is coming back on March the 20th at 10 a.m. I really don't want to wait that long, but I won't be available until then. We've got a couple of dockets next week, but it's the visiting judge who's not going to hear an adversary. So I'm going to recess and come back March the 20th. I don't believe there's any statutory prohibition on that long of a recess. Does anybody disagree?
No, Your Honor.
You know, an extension without hearing the case, there's limits, but we're into the evidence. So I think I'm going to order that recess to March the 20th at 10 a.m. and order that all current orders remain in place. Status quo. Whatever we're doing when we came in here today is what we're going to do until March.
Thank you, Judge. Drake McCaskill, attorney for the department. Ms. Peterman.
Ashley Peterman, Child Protective Investigations.
Jimmy Dresden Mitchell, investigation supervisor.
Irina Gosa, attorney for the respondent mother, Blake Kuykendall. Blake, can you unmute and announce, please?
Hello, my name is Blake Kuykendall. I'm the mother of
Kathleen Savage, attorney for the respondent father, Jamie Castro. We're ready. Mr. Castro, if you can unmute and announce your name for the record, please.
I'm Jamie Castro. I'm the father.
Anna Swallow, attorney ad litem for the child, standing in for Jennifer Harris. Ready.
Amy Harding, Hill Country CASA supervisor, guardian ad litem for the child.
Stephanie Goss, Hill Country CASA.
Christine Liga, CPI investigator, Travis County.
Then with that, Mr. McKeska, I believe it's still your witness.
Yes, Judge, I'd like to call Ms. Dresden Mitchell.
All right. Ms. Mitchell.
Okay, and were you the supervisor for this case?
Yes.
Okay. How long have you been with the department overall?
Nearly 10 years.
Okay, and you familiar with Ms. Kuykendall and her history with the department?
Yes.
Okay. Your knowledge, how many prior children has Ms. Kuykendall had removed from her care?
Your Honor, I would object to relevance.
Overruled.
I believe 8.
Okay. And of those 8 children, do you know how many she currently has in her care?
No, none.
Okay. Are you familiar with the reasons why Ms. Kuykendall's previous children have been removed?
Yes.
Okay, and what's your understanding of the reasons for those removals?
It's been consistently related to substance use by Ms. Kuykendall.
Okay, and is that also the reason for the department seeking removal of Arrow at this time?
Yes.
Okay. During the course of this investigation, what efforts has the department made to avoid removal of Arrow?
Well, so when we became involved, when it came to my unit, I'll start with that. Sorry. When it was assigned to my unit, the department reached out to Ms. Kuykendall and had requested, confirmation of the parties or persons that she expressed that she would like for Arrow to be placed with. We attempted to meet with we attempted with Mr. Castro that same day in order to corroborate that same information that was provided to the initial worker. We requested hair tests from both parents. We actually provided transportation for Ms. Kuykendall to and from her hair test for a urinalysis and hair follicle. However, she declined a hair follicle. The day that we reached out to Mr. Castro, we had asked him, it was an unsuccessful attempt. However, we still scheduled him for a drug test, but learned through Ms. Kuykendall that he was scheduled the following day. So we accommodated that, but included a hair follicle test in which he was unable to complete due to lack of hair. So we then at that point, we ran the checks for Miss Martin, which was one of the parties that Ms. Kuykendall had expressed as a potential person. And unfortunately, due to a history with the department, we were unable to approve her. We then reached out to Mrs. Strunk, Virginia Strunk, and
during the course, we had a few conversations with her, but the initial conversation, we asked the willingness and the ability to care for Astro. And Mrs. Strunk, during that conversation, had expressed that the willingness to care short term, in her words, being about 30 days, but expressed that she would like Ms. Kuykendall or Mr. Castro to live in the home to help care for the child. She identified herself as older, being an older person, and not having cared for an infant in a while.
Excuse me, Ms. Mitchell, hang on just a second. I'm sorry. Ms. Kuykendall, can you please put your device down and hold it still? You're shaking a lot. It's very distracting.
So then I believe that was around the time we had we requested a meeting with Belong to coordinate, kind of figure out, what services that the parents were engaged in. During that meeting, we asked if there were any other persons that they knew about throughout their case that could be like a support or a safety person for the child, and which was provided. The same information was provided. We inquired about why the Strunks weren't previously approved, so then we contacted the Strunks again to talk a little bit more about the process of everything, right? To kind of figure out where they were medically now and what has changed since they weren't able to take Astro in the last case. Based on that conversation, we felt like there needed to be another conversation. We had to go back to Ms. Kuykendall at that point because it was Mrs. Strunk's understanding that she wasn't really aware of why we were currently involved, and it seemed to be like a miscommunication. She wasn't aware of the concerns. So we went back to Ms. Kuykendall and asked permission to openly discuss our concerns in this case and what was going on in order to appropriately assess them. Ms. Kuykendall declined us being able to do that without her present. So we did accommodate and scheduled a meeting that Ms. Kuykendall requested. We scheduled a meeting with Belong, Cindy, the Belong worker, and Mr. Castro, Ms. Kuykendall, and their attorneys. Unfortunately, Ms. Kuykendall was not able to attend due to medical issues. But we held this meeting, was able to, and the Strunks, I apologize, the Strunks were available and present during that meeting. And the meeting it wasn't really successful because we still weren't able to express the concerns that the department had that led us in this case, which again, we felt.
Your Honor, I'm gonna check the narrative. I don't even remember the original question at this point.
So sustained.
Sorry, Judge, I'll ask another question. During the meeting that you were testifying to, were you able to fully address the department's concerns for Arrow being able to return home?
No.
Okay, and just for clarity's sake, why weren't you able to fully address those concerns?
We needed to be able to have permission from Ms. Kuykendall essentially to share the concerns with the department that the department had, with the Strunks. And additionally, Mr. Castro made a statement that we determined to be false in regard to Ms. Kuykendall allegedly not actually using meth. So it was successful because, again, we weren't able to share all the information, but because we were also being given false information again.
Okay. At the time the department filed the petition to remove Arrow, do you think it would have been safe for him to go home with his parents?
No.
Why not?
Well, I would say multiple reasons. Ms. Kuykendall, obviously, she had recently relapsed on methamphetamine very recently prior to the birth of Arrow. And there was inconsistencies in regard to her admittance of substance use with the department. And again, Mr. Castro not being truthful. There was serious concerns about their credibility, to be honest, in regard to the concerns. And have this ongoing pattern of that is evident in their history, both of their histories of substance use for years and years. And despite the department offering services and being provided services, and very recently they have the ongoing services case that they have been actively receiving services for, they've both still relapsed. And we have a very vulnerable child, a newborn, that has been exposed to methamphetamine again. And
objection, Your Honor, narrative.
Same.
Pass witness, Judge.
Mr. Costa.
Thank you, Your Honor. Ms. Mitchell, you said that you requested hair tests from both parents. When did you request the hair test from Ms. Kuykendall?
May I refer to the supplemental affidavit briefly that I have here for the date?
If it's something that has been provided to all parties.
It's the supplemental affidavit that was filed with the courts.
Yes, you may.
The request and the for the urinalysis and hair follicles for Ms. Kuykendall was on January 18th.
And was that prior to the birth of Arrow?
No.
Okay, it was after the birth of Arrow. Was she still in the hospital?
No, she was not.
Okay, when was she admitted to the hospital for the complications she had from the birth?
I do not recall that date.
With regards to the family team meeting, when did that occur?
It wasn't a family team meeting per se, rather it was like an official family team meeting, and rather it was just a meeting that we hosted, the department hosted ourselves. Let me check this for the date as well, please. It was February 6th.
February 6th?
Yes.
And at that time, Ms. Kuykendall was in the hospital, correct?
That was my understanding, yes, ma'am.
Okay, and do you know how long she had been in the hospital at that point?
I do not.
Okay, but she was in the hospital for at least a few days, if not longer, due to the complications from the birth, correct?
That is my understanding, yes.
Okay, and was she in the hospital from the birth of Arrow up until after that time, or did she go back to the hospital?
It was my understanding that she went back to the hospital.
Okay. Is it possible that at the time that she was requested to take the drug test, that she was dealing with the issue that turned into an emergent situation for her to remain in the hospital?
I wouldn't say so, no, because we transported her ourselves.
You transported her where?
To the to the drug testing facility.
Okay, so she didn't refuse to take the UA, correct?
Correct. She took the UA.
Okay. With regard to the Strunks, you testified that Mrs. Strunk had expressed a willingness to help with the child, correct?
Short term, yes.
So why wasn't that attempted? Why wasn't there an attempt to place the child with the Strunks, with the parents present?
Well, I would say that it actually was attempted.
How?
Because we continue to reach out to them to attempt to do those further assessments.
What further assessments?
The further assessments to assess them for a potential safety plan or a parental child safety placement.
You attempted to contact the Strunks?
The department did, yes. We did, in fact, have contact with the Strunks on multiple occasions.
Okay, and did you offer to place the child in the home of the Strunks with the parents present?
We did not offer it. It was Mrs. Strunk, during our initial conversation with her, had expressed that that is something that she felt like she needed in order to help care for the child, was either one or the other. I believe she specifically said Mrs. Kuykendall to reside in the home to help her care. And in a latter conversation that the department had with them, that was still the same. And so we were still considering it. However, because we were not able to really complete an assessment by, assessing their protective capabilities by sharing the concerns that the department had, which was an attempt that we made to have that meeting, and have the permission from Ms.
You did
Kirkendall.
in fact have a meeting with the Strunks, didn't you? And
They were
Mr.
present
Castro was present.
Yes.
Okay, so why was there no attempt made to place the child with the Strunks with the parents present?
Because after that meeting, it was determined that that safety intervention was no longer appropriate.
Why?
Because there was the concerns of the credibility issues. We have to trust the parents and have to have them be open and honest in order for us to be able to trust that they're going to follow a safety plan. Additionally, again, we weren't able to discuss the full concerns regarding all of the concerns, the totality of the concerns that we have, specifically in regard to Ms. Kirkendall, because that permission was not given with the Strunks.
And just to be clear, Ms. Kirkendall was in the hospital at the time of that meeting, correct?
Yes, she was.
Okay. So after that meeting, what efforts were made to place this child with its parents with the Strunks?
Again, after that meeting, that was no longer an option. However, we did go to the home and assess them potentially because we were open to looking at a parental child safety placement at that point.
Okay, and at that point, what happened? If you were open to a parental child safety placement, why wasn't a parental child safety placement put in place with the Strunks?
Again, so after we went to the residence and did a home visit and talked with them a little bit more, the department considered the totality of all the information in regard to the investigation, in regard to the pattern and the concerns with these parents. And the department did not feel that a parental child safety placement would be appropriate in this case.
And is that when the removal was sought?
Well, I believe Arrow was still in the hospital for a little while. I'm not sure of the specific date, but at that point, go ahead.
Just to be clear, this child, the department never attempted to put the child in the home with the Strunks with the parents, correct?
No, that's not correct.
Was the child ever placed in the home of the Strunks with the parents present?
No.
Okay, I'll pass the witness, Judge.
Ms. Mitchell, you testified that the department wasn't able to address the concerns with the Strunks because Ms. Kirkendall didn't give you permission and that Ms. Kirkendall wasn't at the family team meeting. Did you ever reach out to her representative, Ms. Acosta, to let her know that this was authorization the department was needing in order to fully assess the Strunks? Yes or no?
It's my understanding Ms. Acosta was present for the meeting and she only granted the permission.
Ms. Dresden, listen to my question. Did you ever reach out to Ms. Acosta and let her know that you needed this authorization to fully assess the Strunks? Yes or no?
I don't know.
You don't know if you did reach out to her or you did not reach out to her?
I don't believe I can answer that question in just a yes or no fashion.
Okay. Did you... okay. Have the Strunks ever done anything to show that they're not protective?
I'm not sure.
Okay, so you have no specific information to tell this court today that makes you believe the Strunks would not be protective. Is that correct?
I would say that, again, the concerns that they weren't, the department had concerns that they weren't even...
Objection.
I'm trying to answer your question. I apologize.
My question is, you do not have any specific facts today that tells the department the Strunks are not protective. Is that correct?
I do not believe that's correct.
What information do you have that the Strunks ever did anything that would indicate they would not be protective?
I wouldn't say that they ever did anything. I would say the lack of knowing.
Ms. Mitchell, during your investigation, it's typical to reach out to the parent's legal worker. Is that correct?
Yes.
Okay. Did you do that or did Ms. Peterman?
The department did, yes. We talked with them several times.
Okay. So you are aware that the parents were engaging in services?
Yes, it's my understanding, yes.
Okay. Were you aware that all of Mr. Castro's UA tests had been negative?
I don't recall if it was, I believe there was one positive, but I honestly don't recall if it was a UA or a hair follicle.
And you are aware that that one positive was from October of 2023, is that correct?
I don't have the specific date in front of me, no, ma'am. Sorry.
Okay. You know, you were asking the court to remove a child from his parents today. Do you understand that that's a pretty large request?
It should be in the affidavit. If you would like me to refer to the date, I can.
If you have a date that shows a positive drug test for Mr. Castro, yes, please find that for me.
So what I see in the affidavit, the supplemental affidavit, is that we spoke with Cindy Harris on February 5th, and she had shared that Jamie had a positive hair follicle test in November and had admitted to relapsing sometime in September or October.
Okay, so the last positive hair test was back from November 2023, a month and a half before Arrow was born. Is that correct?
That's my understanding, yes, ma'am.
Okay, so you have one parent who is still sober at this time. You've got one who had a one-time relapse, who was honest about her relapse to the department. And you have named individuals who are protective and could be protective. Is that correct?
Yes and no.
Yet the department made no efforts to place that baby with the Strunks with the parents in the Strunks home. Is that correct?
Judge, asked and answered. I believe Ms. Mitchell has responded to this question like on multiple occasions from both Ms. Savage and from Ms. Acosta.
Same.
Can you repeat the question, please?
I'll pass the witness, Your Honor.
All right. Ms. Swallow.
Thank you, Judge. Ms. Mitchell, as part of your job, are you and in your experience, do you have training and education regarding the understanding of drug testing?
Yes.
And as part of your general understanding with your training and your position in regards to drug testing, would a nail bed test reveal one-time use if it were positive?
I'll be honest, I don't know much about nail testing because that is
Your Honor,
very
I'm
rare.
going to object. Ms. Mitchell is not an expert on drug testing. She doesn't have the required education to testify as to what any kind of test would show positive for within any specific time frame.
Judge, I disagree in that Ms. Mitchell, she's a supervisor of investigations. She has a knowledge and understanding of drug testing. I asked her a question. She said she didn't know the answer. So that shows right there where her knowledge base is.
I'll overrule the objection, but if you're going to get into more details about drug testing, it may be appropriate to prove up a little bit more as far as her knowledge, but we can keep going for now.
Okay, thank you, Judge. And same question in regards to hair testing. Do you know whether or not a positive hair test would reveal one-time use?
Based on my training and experience, no, not just a one-time use.
So if Mr. Castro tested positive for on his hair test in November and admitted to relapsing sometime in September and October, your understanding is that is more than a one-time use?
Yes.
In regards to Mr. Castro, was he ever asked to nail bed test?
Not in the investigations.
And in regards to the mother, was she ever asked to nail bed test?
Not in the investigation stage, no, ma'am.
So if the affidavit mentions something regarding a nail bed test, that's incorrect?
I'm not sure. Would you be able to tell me where?
I'd have to find it again, but I will look. While I'm looking, let me see if I can multitask here. Do you know whether or not the mother was at an elevated risk for premature birth of this child?
Objection, Your Honor. False speculation, lack of personal knowledge.
I asked if she knew.
Asked the way it is, I'll overrule the objection, but be careful how you answer, Ms. Mitchell.
I do recall there being information when I read through I believe it was the ongoing legal case, that there was information about her being at an elevated risk. Yes.
Okay. And Do you know whether or not, do you know when her projected due date was going to be for Arrow?
I do not know that. I apologize.
So you, based on your understanding and your conversations with her, do you believe, and it's yes or no, do you believe that she knew she was going to go into labor at 33 weeks?
Objection. Calls for speculation, Judge.
Judge, I'm asking on her personal knowledge from conversations with this mother.
Overruled.
Unfortunately, Miss Swallow, I did not have any myself personal conversations with Miss Kirkendall.
Who did with the department?
That would be Miss Leguez, Miss Peterman, and her Cindy Harris, the ongoing legal worker.
Okay. Are you aware of any current medical conditions that Arrow has? Just your personal knowledge of that. If not, then just say no.
Current, no.
Okay. I pass the witness.
You have any follow-up, Mr. McCusker?
Sorry, Judge, I forgot I had my phone connected. No, Judge.
Anybody else have any other recross?
No, Your Honor.
Okay. Next witness, Mr. McCusker.
Thank you, Judge. I'll let you call Ms. Harris. How long have you been the permanency specialist on that case?
Okay, hang on just a second. Mr. Castro and Ms. Williamson, or Ms. Kuykendall, I want to make sure you understand something. I've warned you repeatedly to be still. The court is allowing the parties to appear by Zoom. I don't have to do that. I can get everybody to come to an in-person hearing if I need to. I need to see both of you, and I need you to be still. I'm not understanding why you can't put your device down and hold it still so that we can conduct proceedings without all the distractions. And if you can't do that, I'll recess this hearing and we'll all go to the courtroom next week. This is the third time I've warned you. There won't be a fourth. Keep your device still. Go ahead, Mr. McCusker.
Ms. Harris, how long have you been the permanency specialist on that case?
Since May of 2023.
And as part of your job, have you worked with the parents and provide services to them to address the reasons for removal in that case?
That's correct.
Okay. What current services is Ms. Kuykendall engaged in?
Currently, Ms. Kuykendall is attending MHDD appointments monthly. She also sees a licensed chemical dependency counselor twice a month. She is also, or had previously completed a parenting class. She has completed a drug assessment.
Well, let me stop you. So, we don't need to necessarily go into all the services that she has completed. What are the ongoing services that she's currently engaged in?
Ongoing would be the MHDD counseling services and the licensed chemical dependency counselor.
Okay. Since Arrow was born, has the LCDC been notified or made aware of Ms. Kuykendall's relapse?
Yeah, I believe so, yes.
Okay. Have there been any changes to her treatment plan since the relapse?
She has completed a relapse prevention plan, but as far as the counseling and services, no.
And has Ms. Kuykendall been able to continue to attend those services since the filing of this case at the beginning of, in February?
Yes, she has.
Okay. Do you feel that Ms. Kuykendall has adequately addressed her substance abuse issues?
I believe that it's still an ongoing concern and something that she continues to address.
And why do you have ongoing concerns?
Due to the recent relapse.
Okay, were you able to speak with Ms. Kuykendall regarding the relapse?
Yes, I have spoken to her.
Okay, and have you been able to speak with Mr. Castro regarding the relapse?
Yes, I have.
Okay, do you feel that they were honest with you based off of your knowledge of the entire case?
They have recently been honest, yes.
Okay, what about right after Era was born? Do you believe they were being honest at that point?
Initially, when they spoke to the hospital social worker, yes, they were honest with me.
Okay. Did Mr. Castro ever deny to you that Ms. Kuykendall didn't relapse, or that she did relapse?
He did mention it during our meeting on February 6th with the investigator. He did mention that there was a possibility that it wasn't true that she had used.
Okay. With Mr. Castro, what services is he currently still engaged with?
Mr. Castro is also attending MHCD monthly, and he sees an individual counselor once a week.
Okay, is he still engaged in any sort of chemical dependency treatment?
Just through MHCD.
Okay, and what is the counseling services that he's engaged in? Is that also with an LCDC?
No, she's just a licensed counselor, but they do address substance use during their sessions.
Okay. Did Mr. Castro also complete a relapse prevention plan?
Yes, he did.
As of today's date, do you believe that it would be appropriate or safe for Atlas to return to the care of either one of his parents?
No, I do not.
Why not?
I believe that there needs to be a prolonged period of time for both parents to show that they can maintain sobriety.
Okay, and whenever you say prolonged period of time, what sort of time frame or would you consider to be prolonged?
I would hope to see at least 2 clean hair follicles before considering placing the children back in their care.
Okay, pass the instruction.
Ms. Acosta.
Thank you, Your Honor. So at this time, is Ms. Kuykendall in compliance with her service plan?
At this time, she is.
Okay. And is there anything else that she needs to be working on at this time?
For Ms. Kuykendall, would just be continuing with the services that she is working on and continuing to submit to the random drug testing.
And at this time, the only reason that you don't believe it would be safe to return the child is because you want 2 clean hair follicle tests. Is that correct?
Due to their history, yes.
And just to be clear, that's under a legal case for another child, right?
Correct.
Okay. And you don't have anything to do with investigations of removal of children, correct?
Correct.
So you wouldn't be able to give any type of opinion on whether or not Arrow should have been removed, correct?
Let
me rephrase that. You don't have anything to do with the removal of the child, correct?
Correct.
Okay. I'll pass the witness, Judge.
Ms. Savage.
Ms. Harris, when or during the legal case, you have tested Mr. Castro for drugs, is that correct?
That's correct.
Okay. And the last positive that you have for him was a hair test back in November, is that correct?
Yes, that's correct.
Okay. And in this, or in relation to this case, I guess, once this investigation started, you sent him back on January 4th for UA, and that was negative? Correct?
January 4th, I don't recall. I would have to.
If I can screen share. Okay. And then you sent him again on January 12th, and that was also negative?
I don't have it in front of me, but I do know that he has been submitting to weekly testing.
Okay, so since the investigation, he's tested for you once a week, and those have all been negative.
Judge, I'm going to object to the witness being able to refer to these documents for her testimony. They have not been proffered into evidence, and the proper foundation has not been laid for them to be offered into evidence.
Sustained.
Ms. Harris, based on your testimony, you've testified you've sent him weekly since January for UA drug testing, and those have all been negative. Is that correct?
That's correct.
Okay. And so that's been since January 5th, approximately 75 days of Mr. Castro being clean, correct?
Correct.
Or actually longer, because the last hair test was in November?
Yes.
And then you sent him again recently for a hair test. Is that correct?
He last completed a hair test in February.
The end of February?
Yes.
And that was also negative?
Yes.
Okay. So in a couple more months, you would be willing to give Mr. Castro his children per your 2 clean hair tests testimony you just told the court. Is that correct?
There's other factors that would have to be considered, and he's still in a relationship with Ms. Kuykendall, so she would also have to be sober and continue to prove that.
Okay. At this time, though, you don't have any concerns that Mr. Castro has relapsed. Is that correct?
No, correct.
Okay. It would just be him continuing in the services that he's completing currently, correct?
That's correct.
Okay. As well as ongoing drug testing and maintaining his sobriety, correct?
Correct.
Okay. I'll pass the witness, Your Honor.
Swallowed.
Thank you, Judge. Ms. Harris, are the UAs that you're sending these parents to complete, are they observed?
No, they're not.
Okay. And do you know whether or not the Mr. Castro has completed a nail bed test?
He was ordered to complete a nail bed test after our court hearing October 4th. I believe he had until that Friday to complete it. They did ask to have that extended to the following week. The following week when he attended, he did not have enough nails to test. So he did not end up completing a nail bed test until, I believe, the beginning of November.
And do you know whether or not the mother nail bed tested?
She did. I believe hers was in October 10th.
Okay. And do you have an understanding of whether or not the results would be concerning?
For Ms. Kuykendall?
Yes.
It was a positive test.
Okay. And how long have you been working with this family?
Since May of 2023.
Is that concerning to you that she was positive on a nail bed test?
It was, yes.
Thank you. I pass the witness.
Any redirect, Mr. McKeska?
No, Judge.
Next witness?
The Department of Judge.
Okay. We're running short on time. Does anyone have any other witnesses to call?
No, Your Honor.
None from me, Your Honor.
Okay. And I just want to make sure I heard correctly. Ms. Harris, you testified that the test was positive for methamphetamine?
On the nail bed test?
Yes.
Yes.
And what month was that? November of 2023?
For Ms. Kuykendall, it was in October of 2023.
Okay. All right. Thank you. All right. Let's hear from the department first, and I'll give Mr. McKeska only rebuttal after I've heard from the ad litem's as well. Go ahead, Mr. McKeska.
Thank you, Judge. The department is asking to be named as temporary managing conservator of the child day, and to name the parents as temporary possessory conservators of the child. I believe that the department has met its burden by a reasonable person would believe that there was a danger to the physical health or safety of the child, which was caused by an act or failure to act of the parents in this case, and it's contrary for the child to return home. In the prior setting, the court heard testimony about how the parents were not completely honest with the department regarding Ms. Kuykendall's relapse right before her birth, or right before the birth of Arrow. The court heard testimony that Ms. Kuykendall was in pain, and even though she's been engaged in services and receiving drug treatment services, rather than seeking out medical attention, she asked her friend Sam for methamphetamines and decided to use because she just decided to use to address the pain. I understand that the parents' drug tests have been clean through throughout this investigation, with the exception of the drug test that mom completed whenever she was admitted to the hospital. But this story is much longer than the last 60 days. This story dates back years regarding their history with substance abuse. They have an older child who is currently in the temporary managing conservatorship of the department for these very same concerns. Ms. Kuykendall and Mr. Castro have had other children terminated and subsequently adopted out for these exact same concerns. I applaud the parents with the progress that they have made in Atlas's case. However, the pattern is repeating itself. And the department believes that it is necessary for Arrow's protection that he be placed in temporary managing conservatorship of the department. I believe the department made all reasonable efforts that were consistent with the health and safety of the child, the health and safety of Arrow. And a lot of attorneys like to ignore that qualifier whenever they're reading the code. Whenever it says reasonable efforts, it doesn't require the department to make every single reasonable effort. It requires the department to make reasonable efforts that are consistent with the child's health and safety. And the department did that, not only throughout investigations, but also the continuation of provided services to the parents during the conservatorship case, and since Arrow has been removed from his family. The parents are asking for the court to order an MTP rather than a removal, and order the parents to complete services. But I don't think that that's a viable solution. They're already ordered to complete services, and they are engaged, but we're still not at a point where Atlas can safely be returned home. And because of that, I don't think that it's safe for Arrow to return home either. The department did look into various options as far as placement, but for various reasons, none of those options were viable to adequately address the concerns in this case. And unfortunately, those concerns date further back than January 9th, January 8th, January 7th, 6th of 2024. Those concerns date back way further than that. And so an MTP just simply isn't enough to be able to address the concerns adequately with regard to Arrow. So we are asking that the department be named as temporary managing conservator today, the parents be named as temporary possessory conservators. I would ask the court waive child support, medical support. I don't want to place additional burdens on the parents. I would ask the court to follow the same visitation schedule that they have with Atlas. I think that they need to be given credit for the work that they have done at this point. And so whatever the visitation schedule for Atlas is, I think it'd be appropriate for Arrow as well. And I think fortunately for the parents, because of the progress they have made with Atlas's case, they're not starting from square one with this case. They are starting with a little bit of a head start. So with that, thank you.
Mr. Posto?
Your Honor, my client is requesting that the child be returned home, and in the alternative that a motion to participate be granted. The department did not make reasonable efforts to return Arrow home. I understand that they're saying that they did interview people to potentially place the child with, but they did have an appropriate home where the parents could be supervised with the child at the Strunks. I don't think that in this case it's appropriate for them to say, well, we did make all of these efforts to place the child with the parents in a supervised setting. They didn't make those efforts. They talked to people. They had someone who said that they could do it for a short-term period. It could have been reevaluated after those 30 days. That's typically what happens in a situation where there's a parental child safety placement in place. Parents are offered services, the child is placed with them in a supervised setting or with someone else in a supervised setting, and the parents continue to have close continuing contact with their child without it being removed. That could have been affected in this case, and it wasn't. And that's not on the parents, that's on the department. Ms. Kuykendall did admit to a relapse. She's engaged in all of her other services. There was testimony that she didn't give authorization for the department to speak with the Strunks. Mom was in the hospital, and I'm not sure that she knew that she needed to give authorization. I certainly did not. I wasn't asked for that authorization to speak with the Strunks from the department. And I think that there were more efforts that needed to be made in order to prevent this child from a removal. So again, I would request that the child not be removed and be returned to the parents, or in the alternative, that a motion to participate be granted. I think that the parents would be open to having supervised access with the children in the home with them. Thank you.
Ms. Acosta, before I move on to Ms. Savage, question. Are you making the argument that the department failed to make reasonable efforts in toto, or are you making the argument that they failed to make reasonable efforts consistent with the circumstances?
Both. I would say both. I don't think that they made reasonable efforts to prevent removal of this child. I think there were opportunities available to them to not remove the child, and they just didn't do it because it's easier at this point to remove the child because they already have another child in care.
Okay, thank you. Ms. Savage?
I'm completely in agreement with Ms. Acosta. I don't think the department made any reasonable efforts to try to return this child consistent with the health and safety of the child. We had the Strunks who were willing to have the parents in the home to help provide hands-on care for the child, while the Strunks could be the supervisors to make sure the parents were sober and safe around the child. You have to remember too, when this meeting was happening, when this one meeting happened and this one discussion happened, and that was it, was 45 days from the one positive drug test we had. At this point, the department is asking to remove a child when Ms. Kuykendall has been sober for 75 days and Mr. Castro has been sober for at least 150. His last positive drug test was a hair test from November. His admission for his relapse was October. He's been sober this whole time. His mess up was getting scared and trying to, negate, there might have been a possibility Ms. Kuykendall didn't relapse, versus just completely being forthcoming, which he admitted in his testimony. He messed up. He wishes he had just been honest from the get-go. He's been very honest with Ms. Harris. He's cooperative. He's doing services. Both of them are. This is exactly why the legislator made the alternative of a motion to participate, because they don't want children in care. They don't want children removed from their parents. We have parents who are willing to address the issues, willing to cooperate with the department, willing to try to make changes. And we understand getting rid of a drug addiction it's a lifelong commitment. This is something the parents are trying to work on. They've been honest. They've been clean. I don't believe the department has met their burden to remove this baby today. Had they filed back on, January 8th or 10th, this might have been a different case. But we're 75 days from the last positive drug test. These parents are engaging in services, and the department had a method of letting that baby stay in this parent's care while being safe. The testimony today is they don't have any specific facts where they can tell you that the Strunks would not be protective, that they could tell you the Strunks broke a safety plan. They never did that. They never gave him the chance. They made a phone call. They said, they only want to do it for 30 days. Technically, the law, safety plans can only be viable for 30 days. But when the parents represented it, that's not true. They never even approached myself or Ms. Acosta to do that. So there was a lot of alternatives the department just kind of ignored and decided, we're going to file for removal once that baby gets discharged from the hospital. And that's exactly what they did. So I'd be asking today that the court denied the department's request, split the baby, so to speak, middle ground, and grant the MCP, That gives us 6 months where the court can monitor the parent's sobriety. We've got 6 more months in Arrow's case, analysis case. Those would coincide when we would be able to fully reunify, if not before then. But to take this baby from their parents and subject their rights to the possibility of being terminated, I don't think the department has met that burden today.
Swallow.
Thank you, Judge. On behalf of Ms. Harris, Judge, I believe that the department has met their burden. I believe there would be a continuing danger to this baby to return it to these parents. The department has been working with this family for near a year, and we still have ongoing meth use. And we have a very vulnerable baby who was born premature, for which I believe, and I believe the evidence shows that, but not for the fact that mom went into labor at 33 weeks. I don't know if anyone ever would have known that she was using meth. And that is highly alarming. I think that the nail bed test results reveal that this is more than a one-time use. If the department has been working with this family for a year, then that nail bed test as of October or November should have been negative. I believe that these parents know how to complete a UA. They know how to complete possibly a hair test. I think this case needs to move forward with all testing available, not just UAs, not just swabs, not just hair tests, but definitely needs to include nail bed testing as well. I think due to the long history with CPS and relapses and drug history, this case needs to be a full legal case. I do not think that kicking the can down the road and a court-ordered services case would be long enough to address the long history of relapses that continue to happen. And I think these parents need a more intensive type of drug treatment at this time. And I do not think it's safe to return Atlas or Arrow to the home. Thank you.
Mr. McCaskill, rebuttal.
Nothing further, Judge.
Thank you, Your Honor. At this time, we are in agreement with the department and with Ms. Swallow. There's a long history of engagement with this family and their substance abuse, and the recent, 60 days, 75 days of sobriety is very limited. And given the age of Arrow and his early birth, we think that he is at a very fragile state and needs stability. If the parents are committed to reunification, then they'll continue to participate and engage in services in this case as they have in their TMC case, and will be given an opportunity to move that process along. However, at this time, we don't believe that it would be safe to return Arrow to his parents. There's still work to be done.
Thank you. There's been a lot of argument about the reasonable efforts made in this case. Before I make my ruling, I just want to point out that the statute requires reasonable efforts consistent with the circumstances. And there's been evidence and testimony both back on March 6th and today about the circumstances of this case, and I'm familiar with these parents and I'm familiar with the companion case. So were this a case where I'd never met these parents before, then the circumstances would look one way, but it's not. It's a case where I'm familiar with this family, I'm familiar with these parents, and I'm familiar with the circumstances being different than a brand new case with parents who'd never been in front of CPS before. So that's what I'm taking into consideration. And I made a ruling in the other case on the same day that we started this adversary that the parents were in compliance, but my notes say, and I'm reading verbatim what I wrote, court is concerned about relapses. Because we've got 8 children now that have been involved with the department because of drug use. And there's a finding in my notes today that the mother, Ms. Kuykendall, was positive for methamphetamines on an nail bed test in October 2023. She was pregnant then. And that's an endangerment ground. It's a clear case law. It's a sports. That's a termination ground. I know we're not here talking about termination today, but that's a circumstance in this case that is very unique. And reasonable efforts are not required to be broad spectrum, cover every basis. They're required to be efforts based on the circumstances of this particular case. I believe that there's sufficient evidence to satisfy a person of ordinary prudence and caution, and the department has proved that was a danger to the physical health or safety of the child caused by an act or failure to act of the person entitled to possession and for the child to remain in the home is contrary to the welfare of the child. The urgent need for protection required the immediate removal of the child, and reasonable efforts consistent with the circumstances and providing for the safety of the child were made to eliminate or prevent the child's removal. And reasonable efforts have been made to enable the child to return home, but there's a substantial risk of continuing danger if the child is returned home. I do not make this decision lightly. I believe that Mr. Castro and Ms. Kuykendall have realized the error of their ways to a certain extent, but unfortunately, the damage is done, and we've got to figure out how to fix it. And I don't believe I can do that in a motion to participate. I've been down that road before several times with parents with drug issues, and I don't have the ability to protect the children and get the parents the services they need that I do in a case like this. So I'm ordering that the department take temporary managing conservatorship of the child. I'm naming the parents as temporary possessory conservators of the child. And I'm ordering the parties to schedule and attend a family group conference to develop family plans of services that are commensurate with the companion case. Now, I know they're not going to be exact, but the parents have made a lot of progress in the companion case, even though concerns still exist. We had to extend that case because concerns still exist, and Ms. Swallow's right. It's been a while. We shouldn't be having these problems. But as Mr. McKeska stated, I'm not going to overlook the work that the parents have done. I'm hoping that you can develop family plans of service that get us on a track to be somewhere commensurate with that case. And I would like to see this situation rectified faster, Mr. Castro and Ms. Kuykendall, than another year. I don't want to do that with you, and I don't think you want to do it. I'd like to see you guys really work hard on both these cases so that we can reunify your family. But we're not going to do that if there's consistent drug use. And I think that you know that by now. It's not going to happen. It's not going to happen with any relapses in this case at this point in time. I understand relapse is a part of recovery, but you've had a long time. And at some point, we have to draw the line and say, you should not be relapsing on methamphetamines anymore. If I was concerned about it on March the 6th, I'm going to be concerned about it on March the 20th. 14 days isn't enough time for me to change my mind. I'm going to waive child support and medical support at this time. The visitation is going to be same as the companion case. And if they continue to test negative and they continue to stay engaged and they're honest, things go well, I'm authorizing the parties to increase the visitation time. Talk about that at your FGC. Next hearing is going to be the status hearing on April the 17th, 2024 at 10:30. April 17th, 2024 at 10:30. I have to admonish the parents. The state of Texas gives parents in CPS cases 12 months to demonstrate that you can provide a safe, stable, violence, and drug-free home for your child. If you cannot do so, your rights are subject to restriction and or termination. I agree with Mr. McKeska that I don't want to overburden Ms. Kuykendall or Mr. Castro at this time. I want them to be able to focus on their services, focus on their children and their visits, and staying clean. So I'm going to continue their indigency status and continue Ms. Savage and Ms. Acosta in their appointments representing the father and the mother, respectively. Mr. McKeska, is there anything I failed to address?
No, Judge, I believe you covered it all.
All right. Mr. Castro, Ms. Kuykendall, when I say good luck to you and that I hope things go well, I mean that. I do. I really want you to be reunified with your children. It's up to you whether you're going to make the decisions to comply with the court's orders and reach that point. There's a lot of people in this room that want to see that as well. But you've got to do the work and you've got to make the right decisions. It's hard. But that's why you have counselors and that's why you have professionals helping you, because it's hard. All right. Good luck to you. Thank you all for your time and your service. If nothing further, all parties are excused.
Thank you, Your Honor.
Thank you.
Thank you.